I'm putting on the mic, you also do so. Okay,
Sorry, Lordship.
yes. Now,
So I beg to mention item number 42 with the consent of the other side, Lordship.
Hmm.
In this case, I am filing my affidavit, Lordship. May give me 2 weeks time, Lordship. I've taken the consent of the other side, Lordship.
Oh, contempt.
Lordship. I've taken the consent, Lordship.
What is the order dated?
It is, Lordship, regarding, Lordship.
When did you receive the notice?
In fact, Lordship, the contemptuous hearing, Lordship, has not received the office assistant, Lordship, received the copy of the order. And what happened, Lordship, she has to hurriedly go to the school of her son, Lordship, because he was not well. So it was not put on his table, Lordship. That is the thing, Lordship.
Mr. Upadhyaya, we will take up the matter when it is called. I don't grant adjournments in contempt matters.
Lordship.
Right?
Obliged, Lordship.
Yes.
Anyway, Lordship, I am filing my affidavit, Lordship.
You file your affidavit, we'll look into it when the matter is called today.
Lordship.
No.
Lordship for listing the eviction. Being town committee has issued a eviction notice without hearing the parties, Lordship. Building.
Motion?
Motion on Friday, Lordship.
When do you want?
Friday, Lordship.
Okay.
May it please your lordship. Item number 67, that's a contempt matter, Miller. It has been listed for orders. It ought to have been listed for motion, Miller.
Hello,
But
we'll take
it's
it
not-
for motion.
Could you be taken up today or Friday, any day, Miller?
No, we'll take it up.
In its
Today
turn,
motion mat dibagita. Silo.
it's a new matter, fresh matter,
66, 67, I think new matters.
new matters. Miller. But in the event the matter, will be in the course of the day, as the
No,
matter is
we'll
called,
take, we'll take it as, after 55, 56, then the matter,
very good.
item number 3 then.
That's right. And so
Yeah.
far as, just a minute. And so far as another writ petition is concerned, we had filed the writ petition, secured a mention. The matter unfortunately is not listed today. May I be the matter be listed tomorrow, Friday, any day? My lord?
Why?
My lord, we had all along been saying that the day from which the fishery was given, it was occupied by other persons in part, and we could not collect revenue of each therein. Couple of years went by, demand was issued, interim orders were there. Now the government admits the position. There's a communication admitting the position, and then a demand notice is issued, my lord. What we say is that it's not that we'll not pay, but if we cannot operate, reduce the rate for that time. When you give us free, you charge the old rate. The admission is there now. Litigations are pending. The admission is there. And on the face of it, then they say you pay the entire thing. my lord.
So it's a motion?
It's a motion matter.
You want to do it today?
Yes. No problem. Obliged, lordship.
May I pray, Your Lordship? May I pray for listing of a motion matter tomorrow or day after tomorrow? It's an eviction matter, Your Lordship.
Hmm?
Eviction matter, Your Lordship.
We'll have it today?
Today, Your Lordship. Public. And another matter, Your Lordship, I have taken consent, Your Lordship. Item number 22, admission matter. Here, Your Lordship, we may not pursue, petitioners may not pursue, Your Lordship.
May not? What is this?
Lordship.
Shall not?
No, that's why I am submitting, Your Lordship. Unless and until I have a written instruction, it is difficult for me to say that they shall not.
Yes, what is the matter about?
It's a, Your Lordship, they have cancelled the tender process. We have put that to challenge, Your Lordship.
You have challenged the tender process.
No, the cancellation of the tender process.
Understood.
No,
So cancellation.
cancel.
Now what has happened thereafter?
No, Your Lordship, they have not filed their affidavit, Your Lordship. I had a talk with my clients, Your Lordship.
And you have obtained an interim order?
No interim order.
So you want an adjournment?
Adjournment, Your Lordship, after 1 week or 10 days, Your Lordship.
Petitioner, the counsel for the petitioner seeks for an accommodation. This is the matter after 4 weeks. Yes, Mr. Das.
Well, there is an item in court number 7, item number 2, my lord. We
Right.
sought for withdrawal of this writ petition, my lord. We got an interim order. Now they said, no, we are going to settle with you. So we don't want to press it, my lord.
Item number, where is the
2.
list? This one good.
7. Item
Item number
2, my lord.
2. The counsel appearing on behalf of the petitioner. It item number 2 of Yadi.
Court number seven.
The counsel appearing on behalf, the senior counsel appearing on behalf of the petitioner submits that he has been instructed by his assisting counsel that the petitioner does not wish to pursue with the instant writ proceedings. Accordingly, the instant writ petition stands closed on withdrawal.
An interim order passed also stands vacated.
The
Okay.
interim order, if any, stands vacated.
Yes, I'm with you.
Permission, may I mention item 66, my lord, it's a
Hmm.
fresh contempt petition.
Oh, that is one. We'll take it.
When I come from outstation, if it can be taken up, my lord,
No, we'll take it. That will be item number 4.
deeply your right.
Your Lordship, I beg to mention for listing a matters in motion for Lordship. Lordship, the grievance of the petitioner is that he is the highest bidder in the settlement process of Fishery in question. But the settlement authority demand bank guarantee for 3 years. Therefore, it brings hardship to the petitioner. As he is a 100% fisherman, so Lordship, he also filed represent.
You want it today?
No, Lordship, tomorrow or day after.
Tomorrow I can't travel.
Day after.
Tomorrow I may not be sitting. I can't
No,
give.
Lordship,
Go and-
day
go and
after.
pursue. You want it today, I can give you, because today I am sitting in this bench. Otherwise, I am not. That is your lookout. I don't want to put any burden upon my brother judges. Then don't mention. Yes.
My lord, this is a matter fixed today, my lord. On 24th listed, my friend from Mumbai has come.
Matter is fixed today.
Today.
Take it up.
Today or tomorrow, I have nothing to worry.
Tomorrow, not tomorrow. We'll take it up today. After at 2, huh?
Month. May it please the lordship.
You inform the other side, Mr. Saiwala?
Yes, sir. I see. May it please the lordship.
Hmm.
My lord, I'm praying for posting of 2 matters pertaining to bench 4, my lord. Next week, my lord. We have some urgency.
You mention it before the regular bench.
Lordship, I'm for a listing of an admission matter. There is an interim against us, Lordship. It was not being listed for 6 months.
Mention it tomorrow before the regular bench.
Yes, please, your Lordship. My lord, I beg to mention item number 1
Ah.
of court number 7, my.
Yes, you want to withdraw?
I withdraw my.
The counsel appearing on behalf of the petitioner submits that he has been instructed by the petitioner to withdraw the instant writ petition, by the petitioners to withdraw the instant writ petition. Accordingly, the writ petition stands closed. Interim order, if any, stands vacated. Item number 1 of court number 7, huh?
Obliged.
Lordship, in item number 6, Lordship, the order is complied with as per the instruction of the client. Order is complied with, Lordship.
What? Item number 6, wait.
This court, Lordship.
We'll see when the matter is called. Whether it is complied or not, don't mention it for the rhyme of motion. Let us cover.
Okay, the Lordship. I beg to mention item number 18, Lordship. Due to favor my senior has not come today, matter may pass back for the day.
The counsel appearing on behalf of the petitioner. 6-1 and accommodation lists the matter of the 6 weeks.
One is-
Yes,
May I please, your Lordship. I beg to mention a matter for withdrawal of matter, sir.
withdrawal today, tomorrow,
Tomorrow. Tomorrow.
tomorrow.
No.
Motion kita dilo. Where is it? 9 o manu kita. You are there?
My lord.
You want to withdraw?
True, true.
Agon is not. In time order, you can invite.
Obliged.
Item 55 promotion.
Yes, Mr. Ghosh.
My lord, here, the rejection of the technical fee on the ground that, my lord, kindly see at page 30,
Rejection of what?
36, can you see? Rejection of my technical. Page 36. Submitted copy of the work.
There was a tender.
Yes,
What happened to the tender? What is the tender for? NHPC?
yes.
For domestic, what is this?
This is regarding supply, erection of testing and commission of 11 kV overhead line.
Hmm.
My lord, the rejection was basically on the two ground. One is 3(1)A of the tender document has not been
Yes,
3(1)A. 3(1)B. Page 20,
3(1)B.
1B. Work experience to the demonstrated meeting in the criteria stipulated in clause 3(2)A shall be provided in form 3 work expense record. Section 3, the work expense shown shall be supported with certificate from the engineering in charge project head of the concerned work. In case the expense certificate produced by the contractor for having executed work for private organization, TDS certificate shall also be produced along with the expense certificate.
Hmm.
Now kindly see my expense certificate, work completion certificate, page 47. I am a registered vendor under the government organization under the North Bihar Power Distribution Company Limited.
Hmm.
And I have completed the work, page 47.
Tell me.
This is to certify that Mr. So-and-so, proprietor SIPL, Infracon is authorized vendor of North Bihar Power Distribution Company Limited. His vendor code is so-and-so. He had done following so-and-so line under the Jackson Limited in supervision of North Bihar Power Distribution Company Limited. This is my certificate. And on the basis of this certificate, my lord, I have submitted my tender. And in the tender document, it says that if I have done work under the private organization, TDS certificate is to be submitted. But here in this case, I have done work under the supervision of the Bihar Power Distribution Company Limited. PSU company. So in that case, my TDS certificate is need not required to be submitted. But even if they are found that yes, TDS certificate is required, then they ought to have been given me an opportunity that you produce the TDS certificate. That opportunity was also not given me.
Now, where is the impugn order? What is the last date? When are they finalizing it?
Finalized, rejected all, yes,
Have they finalized the tender?
yes,
Then what remains?
cancel, not finalized, they have cancelled.
No, what happens to, what has happened to the tender now?
No, tender, there are 3 bidders, all of them rejected.
All have been
All
rejected.
have,
Or now if you become eligible, then you can get it.
then, yeah.
That is why.
That-
We will issue notice only. Nothing else.
If fresh tender is so,
Why? Press tender again participate. What is wrong?
my lord, kindly, on this ground, if they are rejected for the first time on non-existent ground,
Why haven't you made the other people a party? The other two rejected, they may also have a similar grievance. And this court then holds that yes, you are valid. Then what happens? Tell me.
then I will file an application, necessary application for it.
See, then now, as of now, only notice.
My lord, only some
You are
protection.
appearing for Mr.
The Union of India Lordship, otherwise it's against the NHP.
Okay.
Formal part.
We should notice making it returnable on 38/2023. Mr. Arkadeep Chaudhary appears on behalf of the respondent number 8. Pustap. As the respondent number 8 is duly represented, extra copies of the writ petition be served upon him by 28th of July 2023. As regards the respondent number 1 to 7, steps be taken by way of registered as well as usual. Trustee? The petitioner is further directed to take steps upon the said respondents, numbers 1 to 7, by way of dusty routed through the registry of this court and file an affidavit on or before the next stage. The learned counsel appearing on behalf of the petitioner, drawing the reference to section 3, clause 3(1)(b), as well as annex 3(1)(b) of the tender conditions, as well as annexure 5 to the writ petition, which is a certificate issued by the, what is this? Vidyut Apatti Anshal, Muzaffarpur. What is this?
North Bihar Power Distribution Company Limited.
As well as the certificate as enclosed as annexure 5, submits that the petitioner's tender was rejected arbitrarily. He therefore submits that, he further submits that the respondent authorities have cancelled the tender, cancelled the entire tender process, as all the 3 bidders who had submitted their bids were rejected on technical grounds. He therefore submits that the learned counsel for the petitioner therefore submits that as the rejection of the petitioner's bid was arbitrarily done without taking note of annexure 5 to the writ petition, the respondent authorities ought not to be allowed to call for fresh tender, as it may prejudice the petitioner in the instant proceedings. Taking into account the materials on record, this court is of the opinion that if fresh tender is issued, the opinion that the interest of the parties would be duly protected if, but with an observation, would be protected. Taking into account the above submissions and upon perusal of the materials on record, this court directs that any fresh tender, if so issued, shall be subject to the outcome of the writ petition.
Much of that.
56,
My lord, regarding Dosti service, respondent number 1 is in Haryana. Respondent number 1,
Where?
Haryana. Head office is at Haryana.
So get it done through somebody. It is much easier to at Haryana.
Much of that.
Yes.
Villages are located along with the border of from district line. The district bound, and accordingly their land revenue has been paying to the Nagaon district administration. And in 1951, one notification was issued by the then Secretary of the Government of Assam. At page
What is this annexure 9? Let us see.
Annexion 9, my lord.
This is for information to all encroachers that the land you have encroached upon is well inside the Lakijan and Kutan you have.
Order of this honorable.
And by-
My lord, similar order may be, because it is the interim order, my son.
You are therefore given this information to vacate the area with all personnel belonging, etc. within 7 days. Okay, now you are under in the forest area.
My lord, after On withdrawal of this WPC number 1584/2019, my lord, on 26/6/2023, my lord. Next day they issued this order. 9 impugn order, and it was served upon the villagers on 7/7/2023, my lord. Hereupon, we have a next page, my lord, with the GP secretary and members of the AP submitted a representation to the sub-divisional officer SDO, the Sankadev Nagar, my lord, informing that they are going to.
Mr. Dutta, who has asked you to withdraw? You were happy. Why did you withdraw?
My lord,
It must have been when the court
no,
you
my lord,
that we are not going to pass an order. You say, I may be allowed to withdraw. And
No,
approach the
no, my
authority.
lord,
That
I
might
have-
have been the reason.
my lord.
And then now you have withdrawn, nothing happens.
Second param.
So you want the revival of the petition 1584.
No, my lord,
Then what is
because they are.
You on your own volition said that you don't want to press the petition.
No, my lord, because of that, the reason is there, my lord.
Yeah, the reason is very clear how here. Look.
The land, Mr. Uddin Learned Counsel for the petitioners had submitted the that the petitioners do not want to pursue this writ petition as they want to approach the appropriate authority, individuals seeking settlement, allotment of land under the existing.
Who has asked you to do that? You were happy? You were obtaining a stay. Why?
Because my lord, who want to the fakta.
Mr.
You want-
Doctor, I did not take oath yesterday. I've been sitting here for almost 15-16 months.
Well,
I know what is the reason
My
you
lord,
have
it's
done.
clear from the.
When the court caught you, that no, nothing doing, I'm not going to grant that. Further, I'm going to dismiss it. Then you must have said that, look here, let me approach them under the land policy of 2019.
My lord,
And as such,
my lord, in the
the
meantime-
court did not say anything, express anything.
They attack us, my lord.
Obviously.
Put us and destroyed our houses, my lord. But this is latest, my lord.
Isn't it, Mr. Sud?
My lord, the documents, the petitioner annex, my lord, we have filed in the affidavit. Annexer 1, that document we have filed in that particular affidavit. The other documents of the, my lord, of the earlier petition. And the documents submitted by the petitioner himself, it appears that they are the enclosures. Page 32, my lord, if a bay dokolkari jorimana. That is the word used. They are the enclosures, admittedly, my lord, the document submitted by the petitioner in this petition also. Page 32, they are not paying the land revenue, they are paying the bay dokolkari jorimana.
My lord, it is the
They-
government land and
So they are enclosing the government.
Government- I am paying the revenue, my lord.
It is not revenue.
What revenue? That
Okay.
revenue, Mr. Doctor, that revenue, you know, that is the Tozi Moza, that is the penalty.
At page 45, my lord. This is letter, my lord.
Mr. Doctor, by way of this repetition, you want to revive 1584.
No, my lord. No,
So,
my lord. I
okay.
want protection, my lord.
Isn't it the same order which you are asking what Justice Goswami granted you?
Similar, not similar, my lord. Subsequent impugn order has been passed.
Then
my
you
lord.
realize, they got all over, they realize that
New cause of-
we now change the advocate and do the same.
My lord, new cause of action arose.
What is the new cause of action?
My lord, on 27/6/2023.
What is that?
There
Obviously, they will do so. You knew it. You have challenged the earlier eviction proceedings. You said, and the court passed an order not to evict you. You knew it. Then when the matter was taken up, you must have, your earlier counsel must have thought the better of, let me withdraw and approach them under the land policy of 2019. And accordingly, you withdrew with liberty. Now you on 27th, obviously, you knew the consequences would be on the next day, they will go for that.
My lord, subsequently, my lord.
What happened thereafter?
2018, 18 to 19, my lord, the government of Assam took up the matter with the Kaviang administration, my lord.
You know that it was nowadays getting a stay in eviction of government land is one of the most toughest thing. You had that stay. Why did you want to withdraw?
My lord, one at 45, my lord, 45 page 45, my lord.
No, page
DC
45
DC wrote
doesn't work.
later to the chief
Now,
secretary.
Mr. Datta, what do you want? Notice only or dismissal?
My lord,
Other.
my lord, direction may be given to the state respondents, my lord, to protect our property.
That I'm not going to do. Because this is what you want to revive, the
Otherwise,
sale. proceeding.
Otherwise, they will, my lord, they are.
What right do you have to remain in the land?
My lord,
What right do you have to remain in the forest land, more particularly? Where is the forest? Forest is made a party.
My lord, that
But
forest
yes,
of the
my lord.
Caribbean, my lord.
You are the-
Forest
you are
use
the-
are never there.
So-
The forest department evicted, my lord.
Well,
Eviction-
you have evicted
But
them.
my lord, eviction was carried out in consultation with the district administration from Huzai Land Survey on my lord, I think after that, my lord.
After it, you have
That, my lord,
evicted.
yeah, evicted, my lord.
Not
Only
evicted,
13,
but-
or only 13 peoples, they were, my lord, not evicted. Other peoples, they have left the places.
And the petitioners, the 13
That, my lord, there are 4 read petition on that day, my lord, before the Justice Ponish Chaudhary, my lord. In there about, my lord, 3,000, my lord, petitioners were there. In this particular case, they have referred, there are 526 petitioners. In other cases, thousands like that way.
How many?
no, my lord.
526, lordship will look into the, my lord.
No, only 7.
And it-
Like here 7, but earlier annexer 7, in that case, 524 petitioners. Now 7 petitioner approves.
Then what happened? What happened? What order was passed?
My lord.
By Justice Manish Chaudhary, what order did he pass?
My lord, my lord, interim order was vacated, my lord. In all other cases also, my lord. In this particular case and other 3 petitions, interim order was vacated. And thereafter, my lord, we issued notice and.
Now, whether these petitioners are there amongst the 30
My lord.
you are saying,
My lord, if you lordship annexer 7, page 55, name is there, Siddiq Ali.
Annexer
7,
7.
page 55.
No,
But he has
not here. I'm not on this here. You said that pursuant to 27/6/2023,
My lord.
you have already taken steps and
Yes, my
evicted
lord,
these
my lord,
people.
my lord.
Whether the petitioners have been evicted.
My annexer 7, lordship, page 55,
Ah.
he has annexed only the 5 petitioners' name. Siddiq Ali, petitioner number 5 of earlier petition. His name is there, my lord, Siddiq Ali.
No, I'm asking pursuant to this order
My lord,
on 27/6/2023,
my lord,
there was a drive for eviction.
my lord, my lord.
Have
That
you
has been
evicted
carried
the
out.
petitioners?
My lord, all the persons who were the encursers, my lord, they were evicted. Only 17 houses were not evicted. That is by telephonic instruction.
Who are the 17? Are the petitioners here?
I don't know, my lord.
Okay, Mr. Sutya, we take it up at 2. You just get your instruction as to whether these petitioners are there. Otherwise, nothing remains.
My lord.
But Mr. Doctor, you are trying to revive a thing which you have withdrawn. I'm sad. I
Only in
feel
that
sorry
party.
for you. Because now they have approached Mr. Doctor.
Only in that petition was stay was there. In other 3 petition, no stay was there.
We'll take it up at 2.
My lord.
Mr. Sutya, kindly
My lord.
explain it. Yes, Mr. Bonik, your matter. A contempt consider. 16 की बात है.
67 objection. 66, 7. 67.
Yours is what?
Item number 66.
Yes. What is this contempt business?
The judgment of which I am alleging contempt, my lord, is 27th October 22. The lordship will find the effective portion, the directions at page 63, 64. So this matter relates to a challenge, my lord, to the settlement operation which happened in the Kamakhya Hills and the Nilachal Hills, my lord, on the premise that there was no demarcation of the retainable area of the dating law. Now that was rejected, my lord. And certain directions was passed, which your lordship will find at page 63 bottom.
60?
63, your lordship.
Yeah.
Para 12. directions for the reasons and determinations. May I read, Milord?
Resettlement operation.
Made herein above this.
So and so on the basis of
following directions.
government, the outstanding alleged to be prepared in the year 1990. Deputy Commissioner.
The third direction, Your Lordship.
Yeah, that what we need all type of. Yes, you are.
Third direction, I am one of the purchasers of land, Milord, which I purchased, Milord, in 2007, 2008, when there was, Milord, the writ petition was still pending, Milord. The writ petition was.
Where is the direction to give mutation to you?
Milord, three,
It
they
says
say there shall not be any bar by virtue of this judgment in grant of mutation and settlement, etc.
No, there shall not be a bar.
Permissible under law relating to the land.
Giving the
Actionable.
discretion, Mr. Fukan, it will be absolutely a discretion is given to the deputy commissioner.
That's why, Milord,
Don't you think that a writ petition has to be filed instead of this?
I'm coming to that, Milord. Kindly have the representation which I filed, Milord, after this, Milord, page 125 and 128.
Yes, what is it?
This has reference to our, I request for mutation, Milord, 24th March 23.
Then,
Before this, Milord, actually at page 126, Your Lordship will find the first representation which we made. Page 125, I'm sorry. 15th November 22, Milord. I give a background, Milord, to the case, pointing out that permission was given to me for the purchase of the land, Milord. And even the stamp duty was paid at the time of registration of the sale deed. Then, Milord, at para 8 at page 127, I asked them to, Milord, I also extract the effective portion of the judgment, Milord, at para 7.
now tell me,
My lord,
were you a petitioner there in the early?
I was.
Where is it?
I was impleaded, Milord, see the order by which I was impleaded, Your Lordship.
No, impleaded as a respondent.
Responded.
Then how can you be able to ask for this?
I had pointed out that my entire grievance relating to their failure to mutate the land in my favor was placed.
This is the case where you need to file a writ petition.
Milord, I would have bowed down completely, Milord, to what had fallen.
No, not a case for contempt.
Milord, but what I
There's no
see is let them
direction.
at least respond, Milord. They have not even, Milord, 2007 I purchased the land, Milord. I'm completely.
What do you want to do? Withdraw or dismiss? I think you better argue this in the division bench.
Milord,
I'm not going to issue notice on this matter.
may kindly allow me to take instructions in the matter.
No instructions. That is why.
Milord, may just pass
Dismiss
it over. I'll come back.
No, this is not a case out here which calls for anything out there. This has to be dismissed.
Milord, at least.
You,
Milord,
first of all, it is not your writ petition where you sought for a mutation and the court passed an order to grant mutation to you. The court says that if there is there shall not, after making out this assessment by the deputy commissioner, it shall not be a bar to grant mutation to somebody.
In other
There is no
words,
direction.
the due course of law has to follow, Milord.
So if the due course of law is not followed, isn't this a separate cause of action?
If your lordship will notice at para 12, the heading is directions, Milord. Learned single judge clearly starts para 12 by pointing out that it's a direction, para 12, Milord. And it's a clear general direction to the authority.
Mr. Fukan, now you want, just for example, I'm giving you an example. I say that the petitioner is allowed to withdraw. I'm just saying, and liberty or there shall not be a bar on the petitioner to file a writ petition. The liberty is given to you. Tomorrow is going, somebody come and say that I have given you a direction to file the writ petition. No.
That is a clear liberty, Milord. There is a
This
clear
is,
liberty.
this is
and
also that there shall be a bar, there shall not be a bar to grant mutation.
in other words, Milord, therefore the due course of law has to follow, Milord, and they have been sitting on my
Okay.
representations. Milord.
Heard Mr.
So one
A.
judgment,
Fukan,
Milord, I
learned
beg to
counsel
clarify.
appearing on, no, full stop. The instant writ petition has.
Can I show on judgment?
contempt.
Yeah.
No, not necessary.
Because there's a clear direction of the Honorable Supreme Court, Milord, that if it's a general direction, Milord, issued in a judgment, then that has to be followed.
There's no direction.
The
There is
para
no
12
direction that it says there is
Most
not.
respect, Milord, para 12 starts with the heading direction, Milord.
Understood, but this cannot be said to be a direction.
I'm sorry if I've not made myself clear, Milord, but kindly see page 63, Milord,
I've read it.
para 12.
First of all, it cannot be said null and void.
Yes.
What has been said to be null and void is not misconceived or
Yes.
rejected.
Para 1.
The second is that the deputy commissioner has been directed to determine the retainable area.
Yes.
And if it is
The
found that,
retainable area is already determined, Milord.
understood, but then also is directed to verify and determine the retainable area.
My
And
lord.
if the verification is done and there is some encroachment that the deputy commissioner can remove, that is one. The third is there shall not be any bar by virtue of the judgment in granting mutation and settlement, etc., if otherwise permissible under law relating to the land beyond.
That has to be determined, Milord. My representations beg the authorities that kindly determine my rights, Milord, and kindly carry out the mutation. At least they should have responded to my representation with utmost respect,
That
Milord.
is a fresh cause of action for filing a writ petition.
I am relying upon this para 3, Milord, Roman 3 of para 12, Milord, which says that there shall not be any bar by virtue of this judgment. And there was a bar earlier, Milord, 22nd August 2003.
The instant
There was a bar,
application.
an interim order
No,
was
no,
passed,
Mr.
Milord.
Mr. Fukun, I think all these arguments you need to make before the division bench. Now, sit down. Let me dictate. This is an application filed under section filed for initiation of contempt proceedings against the respondent numbers 1 to 4. On the alleged ground, on the ground that the directions contained in the judgment and order dated 27/10/2022, passed in WPC number 6498/2003, have not been complied with. This court finds it relevant to take note of that WPC number 6498/2003 was filed by the legal representatives, was filed initially by one Kamal Sharma, and thereupon the said proceedings were pursued by the legal representatives of late Kamal Sharma. The applicants herein where where are you? Where are you?
There's a order, Milord, page 65, your lordship will find.
No, in this repetition, where are you?
Milord, page 73, I'm shown to be impleted as 65, 67, 68.
No, your name will
73.
be there, na?
So in the memo of parties, Milord, there seems to have been some mistake. My name is not reflected in that, Milord. But there's an order of the court, Milord, page 73.
Page 73.
Yes, I had moved IA 3071 of 2019.
The applicants herein were only one.
65, 66, and 67, Milord, page 73. Bottom of the order, Milord. Page 73, in view of the order passed today in IA.
The applicants herein were included as the respondent number 65, 66, and 67. Full stop. The coordinate bench of this court, by the judgment and order dated 27/10/2022, passed in WPC number 6498/2003,
I'm sorry. to
disposed of the said writ petition with the following directions as contained in paragraph number 12, which is reproduced hereunder. Footstep. The petitioners, the applicants herein thereupon filed 2 applications before the Deputy Commissioner.
Yes.
Kamrup Metro on 15/11/2022 and 24/3/2022
23.
or 23. Seeking mutation of the land on the basis of the observations made by the coordinate bench of this court in paragraph number 12, Roman 3. Of the judgment and order dated 27/10/2022. On the ground that their land have not been mutated, pursuant to the said representations dated 15/11/2022 and 24/3/2023 and closed as annexure A9, A8 and A9 to the instant contempt proceedings. The instant contempt proceedings have been filed. The instant contempt proceedings have been initiated by way of the instant application. This court is of the opinion. Now, in the backdrop of the above, let this court take into account as to whether the instant contempt proceedings is maintainable on the ground that is maintainable on the ground that the petitioners herein, applicants herein, have not been granted the mutation pursuant to their applications enclosed as annexure A8 and A9 to the Deputy Commissioner, Kamrup Metro. It is relevant to take note of that the petitioners herein were not parties, were not petitioner. The applicants herein were not the petitioners in the said writ proceedings. The observations made in paragraph 12, Roman 3, as quoted here in above, only stipulate that the judgment so passed would not act as a bar to grant mutation and settlement, etc., if otherwise permissible under law relating to the land beyond the retainable area. The words, if otherwise permissible under law, confers a discretion upon the respondent authorities to grant mutation and settlement, etc. within the limits of law. The non-granting of the mutation pursuant to the applications filed and enclosed as annexure A8 and A9 may give a cause of action to the petitioners for filing or for assailing the inaction of the part of the respondent authorities for not granting their mutation, but would not certainly grant them a cause of action for the purpose of initiating a contempt on the basis of the directions contained in clause paragraph 12 Roman 3 of the judgment and order dated so and so. In that view of the matter, this court is not inclined to issue notice in the instant contempt proceedings for which the contempt proceeding stands dismissed. You want the liberty? Yes. The dismissal of the instant contempt proceeding shall not preclude this or bar. Let's use the same words. Shall not bar the petitioners, the applicants herein, to challenge the action of the respondent authorities in not granting the mutation if otherwise permissible under law.
Yes, 67.
My lordships, we find this contempt petition for violation of the willful and violation of the order at page 27.
Violation of
The order at page 27.
70?
27.
27. There are so many orders you can close.
The background will be required if need be. So we place it on record.
27 is where?
27 is at page 27.
Yes, what is the order?
No, it states that I had initiated a writ proceeding.
Issue notice making in
There was
India
stay.
intending the letter dated 26/4/2023
That's at page 25.
at page 25.
We had
Well,
challenged
so
this
regarding the
petition.
Honorable High Court inviting the owner to inform me the meeting is convened to discuss on the directions of the plan. In view of the above, I would therefore request you to attend in the discussion along with all related documents at the time and venue. Now, this document was stayed.
Yes, this proceeding was stayed on the count that in the earlier writ petition, that gentleman, Mr. Deb, had said he is not the owner of that property. And therefore the court struck off his name by an order of this honorable court and asked us to approach the authority, the alleged condemner hearing, and he would decide the fresh representation with the present owner, whosoever be. Now, thereafter, this is the first instance where the executive officer issued this 26 for document, jumping over the orders of this court, we did not file in contempt. We came in writ petition. And then this honorable court passed the order at page 27, taking note of the earlier order and stayed. Now, at page 32, the gentleman, he issued the same notice, taking note of the stay order to the sons and daughters of the gentleman. We say there's sanctity of a stay order. That is the only case. Page 32. They are the sons and daughters of Shubharani Dev, who's the deceased wife of the gentleman. There is a stay order of this court, my lord.
So what is your problem?
My lord, if time and again he issues the same notice, despite there being restraint orders by this court,
Where's the earlier restraint order?
that's at page 27.
No, not that one, the earlier one.
The first one is on the restraint order. It records at page 13.
What is that order?
That order reads, page 15 would be that
Page
15, paragraph 6.
13, yeah,
May I read that?
yes.
As the said Govinda Dev, erstwhile respondent number 6 has denied any ownership over construction allegedly carried out over the property earlier by his deceased wife. In the considered opinion of the court, the ends of justice would be met to allow the petitioner the liberty to file a representation before the
Who is
executive.
the
officer.
petitioner?
I am the petitioner.
Your name is Bijoy Krishna?
Dam.
Dam, okay. Allowing the
Sir.
petitioner to file a representation before the executive officer.
Karimgঞ্জ Municipality Board,
For
respondent to
examining
for examining the grievance of the petitioner, which was previously raised by his complaint so and so. On the fresh representation being submitted within 10 days from the date of this order, the executive order shall hear the petitioner and the concerned owner of the construction which is being made by the deceased wife of Govinda Dev.
So that means the executive officer was asked to decide on your representation.
And what he did, he issued a notice to Govinda Dev, who was not even the owner. He walked out of the petition. His name was struck off. That is
No,
on page
here the
25.
notice has been issued to you on 26/4.
Yes, but also to the Govinda Dev, who in the writ petition, he could have contested. He contested and he said, I'm not the owner. So he willfully went away. It was his stand. But the executive officer issued a notice to that gentleman who ought not to have been heard at all. So we came to the writ petition. We did not file contempt. We came to the writ petition. And this honorable court stayed the proceeding. Let me hear what the matter is, who the owners are, what is he doing. And thereafter, he issues a notice to the sons and daughters of Govinda Dev. We say, there's a stay order. At least respond to the writ petition before proceeding with that proceeding. It's my proceeding which is under stay. That is only enforcement order. Again, we have to file a writ petition to get that stay order. Again, he will issue to some other person of the same family. Somewhere the things need to halt. At least not to be erased off. At least that decorum be maintained.
You don't want the thing to be
No,
decided,
it should be. It should be. But he's
or you want it to be decided ex parte.
No, it should be inter party, but not on the jumping over the orders of the honorable court. He's a party.
Okay. Issue. This is an application filed seeking initiation of contempt proceedings on account of the alleged willful defiance to the order passed by this court on 4/5/2023 in WPC number 2405/2023. Issue notice making it returnable on on 1st of September 2023. Steps be taken by 28th of July.
May I pray for Dusty also?
Why?
Let him have the heat. of the
Not necessary.
Like.
Release item number 1, order no steps.
Yes, why no steps? Yes,
This
please.
matter become infructuous, Lordship.
The learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous and as such would not like to press the same. Taking into account the above, the writ petition stands dismissed on as it has become infructuous.
Item number 2,
Madam, give your names in that slip, huh? Yes,
Yes.
why haven't you taken steps?
Yeah,
Same
okay.
problem.
Office order received on 24th, but on 25th, unfortunately, I have taken step. Is
You have
that
not taken steps.
on 25th of 7th?
The learned counsel appearing on behalf of the petitioner is directed to take steps upon respondent within 3 days from so and so, but no steps received, hence the matter is placed before this court. Okay, then we have taken steps when?
On 25th, 7th.
So. 25/7.
Just
You did not take on time.
because it's not.
Okay, we impose a cost of 5,000 to you.
No, see, it is coming with transfer matter where not received. And
So they
that-
don't pay you. No, is it it? No, something to that effect. If it is a transfer matter, you don't get paid
No,
from your
but-
clients.
What I mean is
Then-
they're sent to other.
So we impose 10,000 cost upon you. You have taken steps upon 3 and 4?
Yes,
By how? How?
Postal Talabana or Restored.
What postal? Is it only postal Talavama, not registered post?
Restored, I think. Restored post we have also taken.
Registered post as well as usual.
Yes, sir.
You have not taken.
It is a usual.
This order says respond number 3 and 4 by registered post as well as by usual process within a week from today. Why haven't you taken that? Now you will realize why you should not make so fat repetitions.
Cost of 20,000. Cost of 20,000.
Yeah.
This is, their influence I don't have.
You take it, we'll take it up at 2. Take the steps and then come back again by registered post. It is without the Lama.
State of AP has been served, man. We have received, we will file AP.
No, no, 3 and 4. Who is 3 and
3 and 4 is not.
NHPC? Tuku? At 2. Will 2. Take the other 2 steps. This is postal Talamama. Take it by registered post. By 2.
Yes, definitely. Problem.
Item number 3 for admission.
Yes.
Due to short circuit, the petitioner houses and other properties were reduced to assets.
What is this case about?
Compensation.
Electrical accident.
Short circuit.
Huh?
Short circuit. Short circuit.
Electrical accident.
Yes, my lord.
Yes. Somebody died.
No,
What happened?
is allegedly their house is burned down.
How much do you pay?
The regulations only cover loss of human life and loss of life of animals. There's no compensation scheme or any proposed scheme for payment of for such damages. For that,
Why are you not filing a suit?
we have to file a suit.
My lord, there is a notification.
Show me. What notification is that? We only know about an office memorandum. Where is it? Oh, that is draft. Good. It is draft. Here it is only given amount payable to loss of human life, permanent disability, injuries of permanent, amount payable of so and so, amount of temporary, total disablement, so and so. I think buffalo, cow, yak, mithun, sheep, goat. Huh? We don't fall within
These
the
are the
category.
regulations.
This is it.
And those are the draft regulations. This is the official regulation.
No, this is the office memorandum.
We should in pursuance of these regulations.
Okay, give it to me. Okay, this is for this court, na?
Malot.
So you don't have this. So I think better you file a suit. This court can't decide how much loss it has happened to your house. How can this court decide? Not possible. You want to give evidence?
My lord, my senior is out of state. So the
I can't help
matter
you.
may be adjourned for 1 week. Let it come next week, my.
The learned counsel appearing on behalf of the petitioner seeks for an accommodation on the ground of his senior. List the matter after 6 weeks. Give your name.
Deeply attached.
I'm keeping that.
Item number 4.
The departmental affidavit is awaited, sir. Matter pertains to settlement of fishery.
Affidavit in opposition filed by respondent number 2.
Private respondent has filed, but the departmental affidavit is awaited.
There's a stay.
No state,
Which department?
fishery.
Yes, fishery. Why you are not filing affidavit?
We have already filed.
Oh, they have already.
Respond number 2.
They respond number 2.
Private, no, no.
Yes, filed by the Joint Secretary to the Government of Assam Fishery Department. Then,
We do not have the copy of the affidavit, Lordship. In fact, on the last occasion, the department sought for time to file affidavit.
who is
Your
Debo
Lordship,
Sharma?
There was the last order.
Is any Debo Sharma here?
No.
In your prayer, Debo Sharma, N. Shyam, Miss N. Shyam. No?
Last petition required government time. It is like this.
It was filed on 4/3/2022.
Lordship, probably there is, in fact, this brief has come to me later, probably there's some miscommunication. I'll get the copy and let it come up. Lordship.
And what is this tender about?
Lordship, settlement of fishery. Base 82 is the allotment order. They said, even though we were the highest bidder, they say that we failed to submit certain documents.
Page 43.
Base for 82.
82 is not there. What is this? 82 of what?
The writ petition.
What matter is this? I am here, Chitra Das.
Yes.
Chitra Das, how many pages are here? I don't think there is so many. Repetition finishes there at page 43. What repetition you are holding?
Here also it finishes off at 43,
You don't know.
annex of 5.
Oh. You must have got the wrong book, wrong file.
2744. WPC 2744. Lordship, there is one, in fact, there is one more writ petition, probably Lordship, that is, there is a confusion regarding the.
Then
maybe
what do you
after
mean?
the wrong date.
I don't
I'm
think
sorry,
anything remains in the instant petition.
Yes, that matter has become infectious, Lordship.
This
prior to
one,
the
nah?
Yes, prior to the settlement, one writ petition was filed. Once the settlement was made.
A reader should not be issued directing the respondent to settle the hearing in favor of the petitioner society. This is the writ petition. And I think thereupon it has been settled with somebody else.
Yes, yes,
So you are challenging that.
yes, that's not there.
Here,
Yes, nothing remains there.
the counsel is appearing, on behalf of the petitioner as well as the the counsel appearing on behalf of the petitioner as well as Mr. N. Goswami appearing on behalf of the government.
As Burwa.
Ed Burwa appearing on behalf of the government has submitted that that as the settlement has already been made in favor of a in favor of has been made to some third party. And there has been a separate challenge being made to the said settlement. Nothing survives in the instant petition. So taking into account the above, the instant writ petition stands closed as it has become infructuous.
The file of the other writ petition.
That
I'm
is
sorry.
why. 5. Madam, who has got it? You must have got the file of the other writ petition.
Yes.
Give it the name instead of putting the third part.
For her.
I think you must have made him a private respondent.
Yes. For her fishery, Samavai Samiti Limited.
Have already been settled in favor of Hetu Namtulile. Just ask him to give the name.
Yes.
And as such, nothing survives in the instant. Yes, who is there in item number?
5.
555.
My lord, this matter has become infructuous, so.
Okay. The learned counsel appearing on behalf of the petitioner has submitted that the instant writ petition has become infructuous. Accordingly, the writ petition stands dismissed as it has become infructuous.
My lord.
6.
As per the instruction of the petitioner, order is complied with, Lordship.
Complied with.
Lordship.
Order is complied means what order has been complied?
Money,
You have got the money?
Lordship. Lordship.
You have got the money. Okay. The learned counsel appearing on behalf of the petitioner submits that the amount claimed in the instant writ petition have already been received by the petitioner. And as such, the petitioner would not like to press the instant writ petition. Accordingly, the petition therefore stands closed and withdrawal.
7.
Yes.
In this case, Lordship, we have filed an application for demarcation of land.
Ah,
That has not been the Lordship done till date, Lordship.
yes, why haven't you done that? Simple matter.
Yes, Lordship, subsequently, the notification has come into force 2020, whereby he has to file it in the standard form. Let him file and we'll just dispose it of within the time.
My lord, already we have filed
No, that is an application.
additional affidavit.
Additional.
Additional affidavit.
Yes, what are you asking for?
My lord, earlier also that was what for as per this honorable court order, Lordship, we have filed additional affidavit annexing the application, Lordship.
No, I'm asking you, what are you asking for? Writ of mandamus issued directing the respondent to demarcate the land as paid for
That
under
is
tax
possible,
of
Lordship.
so situated at so and so. So this is your prayer.
Fine.
Anything else? Okay. Yes, why haven't you done that?
No, subsequently, he has filed in the standard form. So on that basis, we'll dispose it of.
You do it. The instant with petition has been filed by the petitioner, alleging inaction on the part of the respondent authorities, more particularly the respondent number 5 and 6 in not demarcating the land of the petitioner under patta number 7 and under DAG number covered by DAG number 42, 43, 44, 46 to 59 of patta number 7 included in patta number 7 as well as DAG number 61 and 62 included in patta number 8 situated at Revenue Village Digor, Pulor Tol under Lokipur Revenue Circle, Kachar. The learned council. Mr. Borua, is your instructions proper?
Yes, in fact, there is a confusion. He has subsequently made another application whereby he has prayed to the assistant settlement officer to demarcate. So this is a continuation of his previous application, but he need to file it in a standard form, which he hasn't done. So he may file it within immediately and will.
The learned council appearing, Mr. S. Borua appearing on behalf of the respondent revenue authorities. Respondent number?
3, 4, 5.
3, 4, 5, and 6.
Respondent number 2. Oh, no. 3,
Director of Land.
4, 5, and 6. Submits on instructions that that for the purpose of seeking demarcation, there is the application is required to be filed in the proper format, which the petitioner has not done, and as such, the said applications so filed before the circle officer as well as before the assistant settlement officer had not been taken note of by the said respondent authorities. Mr. M. Khan, appearing on behalf of the petitioner, submits that the petitioner shall file application in the proper format within 15 days from today. Taking into account the above, this court therefore disposes of the instant with petition, thereby granting the liberty to the petitioner to file an application seeking file the application.
Yes.
Seeking demarcation of the land of the petitioner, the details of which have already been mentioned here in above. To whom?
Circle officer.
Huh?
Circle officer.
To the respondent number 5, that is the circle officer, Lokipur Revenue Circle, and the said respondent number 5 shall thereupon within
30 days.
30 days thereupon, within 30 days thereupon shall take appropriate steps for carrying out the demarcation of the land. Full stop. By 30 days thereupon, by giving appropriate notice to the by effect, not 30, 45 days. By giving appropriate issuing notices to all concerned.
8.
Yes.
This is essentially a matter of handling commission of food grains.
Oh, that day matter, I have heard it, something similar to that, no?
Yes, Lordship. And Lordship had asked me to pay the court fee for.
Ah,
the
this
petition.
one.
That is what, that is
That
item
is a
number
different
10.
matter.
That is item number 10. And this is item number 8, similar matter.
There you have paid,
I have paid. Lordship.
here you have not paid.
Here it is only one association,
Okay.
registered association.
Item number 8 and 10 AK.
8 and 10.
Yes, tell me.
This is a matter where already the government has admitted to our dues.
Hmm.
There has been a previous proceeding also wherein the Advocate General has appeared and the Advocate General has categorically, case 97, the Lordship will see, have categorically stated that we are entitled to that amount. And based on that, those petitions were allowed and money was also released. Now we are also claiming
Similar relief.
similar relief because the entire money,
Yes, why you are not paying?
Well, the.
page 97, Lordship can find that, page 97, Lordship will find that admission.
Well,
Now we are entitled.
That was an order, my lord, because at that point of time, fund was available with us and from our side, my lord, it was submitted that this may be released, otherwise this subsequent fund from the central government will not come. But so far this case is concerned, my lord, claim is concerned, Lord, I have checked up what is the, because after the, as per the decision of the central government, my lord, that particular division of commission at 70%, 30%, that has been stopped.
Why?
Now.
How can
Earlier,
it be stopped when it is it is statutory mandate?
no, it was, a decision was taken by the government in 2016 to give 30% to the GPSS for transportation and 70% of that amount to the fair price shop. That central government now by subsequent instruction said that that particular 143 rupees, the entire will go to the fair price shop. So nowadays, it entire goes to the fair price shop. Now they are not getting that amount.
So there is no transportation done by them.
Transportation is there, but a new system has come for transportation. The amount comes separately from the share of the fair price shop. 143 rupees. No division is there as on today. The entire amount goes to the fair price shop. Transportation amount is different. So the
Period of dispute herein is different.
April,
April 2020 to November 2020. I'm not claiming now. It is the fund that has come for April 2020 to November 2020, for which release has been already made in 3 districts pursuant to the Advocate General's
Yeah.
submission. That
yes,
they are
Lord.
entitled.
In
I'm
Nagaon,
claiming that amount only.
Nagaon,
Nothing more.
Morigaon and Dorong, that amount has been released. Thereafter, no fund has come and there is no fund.
No,
But-
but when did the central government's decision come?
It was in 2020. Lord.
When?
Case 56, possibly kindly. Case 56. They say from the financial year 2021, 2022 onwards, page 56. So I'm not claiming onwards. I'm claiming for the money that was previously done. For the work that was previously done. Page 56, possibly kindly see.
21, 22 will be for March, April.
Correct.
Yes.
Then why you are not paying for the month of 2020 onwards?
And the present fund, you have to find it page 99.
Your period is with, what is the period for both the writ petitions?
Page 99, Lordship will find the funds. April 2020 to November
November
2020.
2020.
Page 99. The fund has come already.
No,
The fund was there. They had diverted the fund now.
You can't do that.
And that is why they are saying that the letter
So,
says,
on one hand, you are saying that the fund has been not paid by the central government.
No.
Page 99 of CPC.
Thereafter, no more fund is
It's
coming.
not
for that.
whenever you say something, we take it on the face value.
No, my lord.
This is a different thing what
No,
you are saying from what you had said earlier.
No.
You said that the central government had changed the funds. Understood them.
With Lordship.
But that is not so. He is asking for a particular period. And during that period, you have got the fund. Why haven't you paid that?
My lord, whatever fund is available, that has been already given to the GPSS of Nagaon, Morigaon and Dorong. My instruction is that no further fund is lying with them.
Page
That
99.
is my instruction, Lord.
Lordship will check for page 99. The entire district fund.
In fact,
So what is this fund? This document which is there at page 99
Lordship will
NHI.
read the heading, Lordship will find everything is clear, Lordship.
Here, these are for various districts.
Yes. So it has
Statement
come-
showing the district-wise commission amount to GPS as per the Honorable High Court's order dated so and so for additional food grains allocated by the Government of India under the so and so to be paid by the Government of India. So this is by your director.
I'm
At
keeping
the
this-
honor that as per the Honorable High Court's order, written amount of rupees so and so as commission to be paid as central assistance from so and so. Accordingly, budget has been allocated to so and so. Requested to submit financial figure. Statement showing the commission amount to be paid to the GPS of.
এখানে জানো 20 জানুয়ারি এখানে 111 starting
I'm coming after 5 minutes.
starting to page number to milan
Pursuant to that particular statement, if a lordship will see at page 102, in fact, 19 crores was also sanctioned and released by the central government, page 102. And the entire money has been diverted to the fair price shop owners. Though the scheme was 2021 onwards, they will not pay. And this is the money that is prior to that period. I'm not claiming onward, but that period for which we had worked and for which the Advocate General has already submitted and admitted that they are entitled. At page 97 of the judgment, lordship will find this.
Where is it? Have they filed affidavit?
Yes, lordship.
What is their stand?
Specifically, they do not say anything, lordship. They are only talking about various schemes and all, but they do not hit on this exact aspect as to whether we are entitled or not, and whether what about the AG's submission in that petition, in that proceedings, lordship. There's nothing said about that. They're only saying that as per the central government scheme and all, the money is to be given to fair price shop owners.
But there is some difficulty with my files, Malad. Because of these similar names, Malad, wrong file has come to me, Malad. Kindly take up at 2, Malad. Let me have the correct file, Malad.
You say
With similar names,
that
Malad,
matter which I dealt with 50 and above,
50 and 11.
it's called the fair price.
Yes.
There, the Advocate General had placed the office file. In the office file, they say that the government is going to take up, would give the benefit of 143 rupees, which is there, the fair price owners.
Yes.
However, without curtailing the commission. It is written out there, if I remember correctly. We produce the records as regards this.
Malad,
We'll take it up on some other day.
Malad. I'll have to get the record. I'll take it.
Because the records I remember, because that was the specific submission he has made. That we are going to give the benefit, all the benefit to the fair price shop. However, on account of, as we are giving the entire benefit to the fair price shops, now the logistics on the basis of which the transportation is to be carried out by these cooperative societies. That would be difficult, so we are doing it by ourselves. And as such, if we have too many fair price shops, there will be difficulty. And as such, we are having this 50. That was the logic behind it.
One of the logic.
Presently, they are getting 26 rupees. The Gawapacha Sabha 7 level committees, they are getting 26 rupees now. That is the present, after the present decision of the government, they get 26. Earlier, it was 143 rupees. Of that, 30% comes to around 42.90 was for the GPSS, and the rest 100 point something was for the fair price shop. So it's a two-tier system. From the FCI go down, it is the GPSS who collects it, and from there the fair price shop ultimately gives it to the consumer.
No, I have dealt this aspect in detail in my that judgment.
Yes, that
And
Now-
there I have mentioned how the division happens, how it.
Now, Malad, the system is totally different. No percentage of money will be given from the fair price shop owner fair price shop owner to the GPSS.
So that is your reason
Tran-
why.
Transportation
That
is
if there are
completely
too
different.
many fair price shops, the
They
logistic
have cut it.
expense
Lordship,
which the state would have to bear would be more.
more.
So that is one of the reasons
That-
why you don't want to have more than 50,
Now,
less than 50.
Yes, yes. Now the tier 1 and tier 2 system has been introduced and this particular cases are, Lordship, I'll get the record.
We'll have it on when? Day 24th, 26th. We'll have it on 9th of August.
9th, Lordship.
The 9th of August, I will not be here. After that.
16th of August.
Correct, Lordship.
Yes, Your Honor, 16.
Please, this matters on 16th of August 2023, on which date the learned counsel appearing on behalf of on which date Mr. D. Nath, the learned senior government advocate, shall produce the records pertaining to the payment of the commission and decision thereupon taken not to grant the pertaining to the payment of commission to the cooperative societies in question.
But this is under a particular scheme, PMGKY, for the period April to November. I'm not thereafter
Malad-
claiming. So it's
Malad,
only
this-
that money
This
During the
division,
period
from April 2020,
2022,
November 2020,
November.
under the PMGKY scheme, Pradhan Mantri Garib Kalyan Yojana. It's only that money I'm claiming, nothing beyond that.
under PMGKY, no division is there, no commission will be getting. Under NFSA, they used to get the commission on the NFSA rise, for the NFSA. rise.
yes, you were getting an
PMGKY is a
NFSA.
COVID, for the COVID period.
This is a particular rule you are having, na?
Yes,
This
yes.
is made under that particular rule, how it
2015,
happened.
2015, yes. we
Yes,
have.
that is annexed in this.
We have. And Lordship may also,
Shall produce the records, but produce the records pertaining to the payment of commission to the cooperative societies for the period from April 2020 to November 2020.
and the record, that record will be different, record where the decision for limiting 50 ration card has been taken. That
As
file
well
will
as
be,
the records relating to the decision of the government, the policy decision of the government pertaining to limiting the fair price shops to 50 and above ration.
Both the matters will be tagged together. Matter number 10 also.
8 and 10.
One order,
Similar. Lordship.
one order did be done.
Obliged, Your Honor.
Item number 9,
May I have a-
Yes.
So the last occasion on 17/7, the trustee passed an order directing them to file the affidavit. They filed affidavit, they established a copy to her. The matter relates to subsidy under the trade subsidy scheme.
So 31/7, everything will finish.
No, not everything will finish, my lord. They said that up to 31/3/2017, whatever claim there is pending, my lord, they should submit before that, otherwise they will not be entertained. And our claim is a part of that claim is from, my lord, 1/1/2017 to 31/3/2017.
So that has to be submitted
That has to be submitted. Now, my lord,
before.
if, my lord, they have not processed it because, my lord, their ground is that, my lord, the trade subsidy scheme came in 2013. My lord, we are already registered under the transport subsidy scheme of, my lord, there, and we are registered. My lord, I'll come to that one also from the scheme itself. Now, my lord, since, my lord, there is a, my lord, in clause 17, my lord, it is the authority, they have to, my lord, transfer our registration from transport subsidy scheme to, my lord, the trade subsidy scheme as per clause 17. They have not done. Then in, my lord, 2014, we have given an application to them, kindly do it. They were not doing, kept pending, my lord. In meantime, my lord, in 2017, we started commercial production. Now, my lord, thereafter, my lord, in 2019, my lord, they have issued a letter that they have registered us from the back date, my lord. From the date when, my lord, our registration was under the, my lord, transport subsidy scheme, that is in, my lord, 2012. And they said that though registration has been made in 19, my lord, it will have the effect from 2012. In spite of that, we submitted our claims thereafter. Now, the claims, my lord, some of the claims, my lord, were forwarded from general manager to the district industry director, my lord, for the processing. There are different steps for processing and all that. Ultimately, it goes to my lord, state level committee, and thereafter, my lord, ultimately the my lord, if they pass it, my lord, then the dues are, my lord, paid and all that. Now, nothing has been done, my lord. They have kept pending. They said that since you have been registered in 2019. And you started commercial production in 2017, you are not entitled as per clause 8 of the my humble
As per?
clause 8 of the scheme. My humble submission that we do not come with the purview of clause 8. We come within the purview of specifically under clause 17 of the scheme. It specifically says that the person who are already registered, it the authority duty to transfer their registration from transport subsidy to the freight subsidies.
No. First of all, you were registered under the transport subsidy of 1971.
2012. Yes.
1971.
Yes.
When did you start your commercial production?
2017.
2017.
I think 27/3/2017. Like I have given a date.
So you were entitled to transport subsidy in terms with, as per the transport subsidy
Subsidy
Act of
scheme, but in the meantime,
71 or but the
No,
transport
no.
subsidy have been as per the industrial policies, it has been given the benefit.
no, what happened, my lord? 71 transport subsidy scheme was there. But government decided that we will not continue with the 71 scheme. So freight subsidy scheme 2013 has been dropped sometime in January. Now it says that new industrial unit, existing new industrial unit, they can get registered. Process has been given in the subsidy scheme.
But how did you get your registration in 2012 when you came to had the commercial production in 2017?
So we started, the factory laying the everything we started. Then we got it registered.
Okay.
Under the scheme. The production was not started till then. We got it in 2012. So I have the copy, I'll just go to my lord. Then, since 2013, the freight subsidy scheme came. Now, we are under because of provisions of the clause scheme, clause 17. It is the authority they are they are supposed to transfer or convert our registration from transport subsidy to freight subsidy.
Where is that?
Your lordship will kindly page 53, page 52, my lord will come first. Last line.
This is this freight subsidy
Yes,
scheme.
yes, sir. I have an explanation. Your lordship starts from page 41.
Of 17. Announced on so and so
My lord, page
will
50.
cease to operate with effect from the date of notification of the upon new units, industrial units, which have reported commencement of product before the notification of the scheme. And subsidy is being claimed by such industrial units. So 1971 will cease to operate with effect from the date of notification of the scheme for new unit.
My lord, your
Let
lordship will
us see what is the definition of new units. It will be here.
new unit, my lord.
New industrial unit
New
means
unit
industrial
where
units
manufacturing a
where manufacturer has commenced on or
Or
after the date of
publication of the scheme in the-
publication of the scheme in the official gazette. So therefore you come under the new units.
New unit, my lord. Now, my lord, your lordship will kindly see. I'm reading, my lord, the same page 53, line about fifth line. However, an industrial unit, my lord, this is important.
Register, we have
Registered under the TS, which has not claimed subsidy under TS 1971. Before the date of publication of freight subsidy scheme 2013 in the official gazette, will be covered under the freight subsidy scheme as new industrial unit, provided it is otherwise eligible for subsidy as per the provisions of freight subsidy scheme. Registration of such industrial units under TS shall be transferred to registration under the freight subsidy scheme by the concerned district industry center.
Okay.
So my whole submission is from my lord that they are relying on clause 8. Clause 8 is not for me, my lord.
Clause?
Clause 8. That, my lord, your lordship will find at page I'm sorry, page 47.
Desirous of claiming subsidy under the scheme shall get benefit. Okay, then
That is not. Eight says, my lord, industrial unit desirous of claiming subsidy under the scheme shall get registered with the district industry center prior to the date of commencement of its commercial production for new industrial unit or before undertaking substantial expansion for existing industry. So my case will not covered by clause 8. My lord, my case will be covered by clause of paragraph 17.
but did you claim the industrial transport subsidy prior to
No.
this?
Commercial production did not start. My lord. It was started in 2017. So I made the claim from 2017 onwards. Prior to that, I am not entitled to.
So you have not claimed.
And my claims are, my lord, I have already annexed. My lord, they are also, my lord, recommended by the general manager. If your lordship kindly, I am just showing one, my lord. Page 68, my lord, will kindly see. Page 67. I'm just showing one, my lord. There's several. My lord, this was in 2019. I have forwarded, my lord, with all. This is 1/1/2017 to 31/6/2017.
So you gave in 2019.
I'm not 19 because, my lord, registration, they have informed that my registration has been done.
Then from the general manager, it has gone to the Commissioner of Industry.
Industry Commerce Department.
Then the Commissioner of Industry, what do they do?
No, they have not done, my lord. Now, my lord, since they were not processing the matter, my lord, then we have made a representation. No, before that, my lord will kindly come to page 78, my lord. I'll just show the registration, my lord. That will be important. Page 78. Well, this is the letter in 1/6/2019. They are informing that your registration. I am to inform you that TS registration of your unit granted by letter dated so and so 5/3/2012 by TICC Kamrup is hereby converted. My lord will kindly see the word converted to registration under FSS as a new unit and allotted the registration number so and so dated 3/3/2012. Issued on 31/5/2000. Even the authority themselves say that the registration has been, though it was registered in 2019, it relate back to way back to 2012. My lord, your lordship will find down below also the note in the same. Down below note, this is a case of conversion of registration under FSS from TS registration bearing number so and so.
Now, what is the industry department saying?
But industry department saying, at page 80.
And what is net fee saying?
So net fee has no role at this stage. Because they only distribute the money,
You are the disbursing authority.
Dispersing authority, they are an order agency for dispersing. Since they are no longer.
And the industry department, they filed the affidavit.
Well, they have.
Yes,
filed an
sir.
affidavit.
What is your
Before
stand?
that, my lord, page 80, my lord, will kindly look at it.
Page?
80, my lord, which is, before challenge because it's honorable.
Yes.
With reference to the subject cited, I would like to inform you that as per the legal opinion, so and so obtained from standing counsel, the claim made by Jericho LLP and the unit has gone for commercial production in month of March 2017. And at that point of time, the mandatory registration under the Industry and Commerce Department was in the name of Jericho Chemicals Private Limited. In January 2019, the unit has again changed the constitution from private limited company to a limited liability partnership. So and so. However, its TSS registration was not converted to under FSS. So the unit went for commercial production under Jericho Chemicals Private only. As per section 8 of the trade subsidy scheme, now that has been quoted here. As per so and so, any unit is eligible to claim trade subsidy can claim same only if the unit is already registered under the aforesaid scheme prior to its commercial production. Since the registration of the unit did not get it registered covered under the trade subsidy scheme prior to its commercial production, the unit cannot claim for trade subsidy scheme under the aforesaid scheme. But their whole contention is that since we have registration in 2019, so it relates back to 2012.
No, their whole contention is that you were initially registered as a company. Now you are an LLP. So under such circumstances, you have not changed that or sought any amendment to that particular registration. Isn't it? That is the
But my lord, all the application has been filed, my lord. That has been already granted, my lord, changing the, my lord, constitution of the,
Where?
your lord, you will find here.
Page of registration, page 78, na?
That, my lord, they have registered on 78. Well, that was given in the name of.
This registration is done under LLP.
And
Your commercial production is done under the company, private limited.
Company, yes.
something. Well, it's a change of constitution, my lord. Your lordship will kindly consider that aspect of the matter.
I understand, but that is the only issue.
My lord, your lordship
We
will
are
kindly-
not on any other issue.
Look, constitution has changed, my lord. But my lord, everything remains same. It is not that, my lord, Mr. Kamar Agarwal has changed, my lord. I have changed my name. I am the same person. And my lord, your lordship will see that, my lord, there are various decisions of the Supreme Court also, my lord. On such ground, my lord, they may not, cannot, my lord, disclose as for, my lord, receiving the, my lord, the benefit of the subsidy. Their affidavit, their plea is the same, my lord. Now they have come up with a new case, my lord, that in 2016, there is a notification from the central government. They say that the central government says that we are not continuing with the, you know, subsidy scheme of under the FSS grant. Their FPTP in opposition, which your lordship kindly take.
When they are affidavit in opposition, I am not getting it anyway. What affidavit pass, eh?
It filed on 24th, my lord. We have
That
received
is
a
what I
copy.
will say.
Yeah, 24th we have filed yours.
May not be in the record also.
It has not come on record. Yes, what is your stand in the affidavit?
The lordship that our stand is very simple, only one very simple.
You are appealing for whom?
That email, respond number 9.
You are only the disbursing authority. Yes,
So our stand is, lordship, this the freight subsidy scheme 2013. Under section 8 of that, lordship, my learned senior has already read it, but I'll just read it once again. Because this is in page 47 here, lordship. So what it says, like there is a precondition for getting the benefits of the freight subsidy scheme.
so you have to be enrolled before.
You'll have to register it. Then before your commercial production starts. So that is must. Then once it is done, then only you can claim for subsidies. Now that in this case, lordship, what has happened is like
They have registered as a company.
they have raised as a company, first of all. Secondly, that was under TSS scheme, which is no longer there. Then they have, of course, they have made an application, dear lordship. They have made an application for conversion of.
When did you become LLP? Have you asked for changing the registration then? As
Yes.
LLP?
That is we have. You know, we have.
Because your registration which have been given at page 78 is in respect not as a company. It is given to a company, not the LLP.
The change of LLP is, you know, 12/3/2018 by the page 39.
12/3/2018. So after the date of commercial production.
Yes.
22, I'm sorry, 22nd of March 2018.
So 22nd of March 2018, that means you have changed the constitution
Yes, madam.
after the date of commercial production.
After the date of.
So prior to the date, you were the company.
We are the company.
Now, did you ask for change of that the certificate?
Page 62, just a minute. Madam, page 63.
What is that?
We have made a request to Madam change.
For changing?
Yes. That page 63, annexure 6.
Page 63.
That is in 2019.
That's good.
Anyway, 63.
24/1/2019.
Now, how did you change from company to LLP?
Detail is not here.
But Mr. Agarwal, that is your point. And you just look into one judgment just before my elevation that I may read a matter pertaining to some cement, JUD cement or something. They were also a company, they became an LLP and all these things. And the authorities were not granting, no, I think some other matter. I'm not getting it. The authorities were not granting the benefit because of the fact that it was an LLP. You have changed into LLP. Now, what is the effect on the scheme if the constitution changes? Is it mentioned anywhere?
No, there is nothing.
If it is nothing, then in that regard, what will happen?
Because, my lord, it says that, my lord, the industrial unit, my lord, it not say that company, private limited company or LLP, my lord, there is no distinction. Even a partnership firm can, even individual proprietorship can perform. Lord, your lordship, can you see the definition in the scheme?
The registration will be given to whom?
My lord, the industrial unit.
Okay, let us see that.
Page 41, my lord. May I read, my lord? The government of India has approved the following scheme for grant of trade subsidy to eligible industrial units located in the selected state, district in the transportation of raw materials and finished goods and from certain selected areas and all that. Then,
Because the only problem which arises is once you get this thing, this obstacle over, then you can get it.
Yes.
We only need to overcome that obstacle. That this company too, yeah.
something
If it
directly.
is, if we take it that it is the industrial unit, so what will be the meaning of the industrial unit meaning? The industrial unit means any
This is where a manufacturing activity is carried on, page 52,
2E,
2E,
Any manufacturing, lordship.
and manufacturing activity.
where manufacturing activity takes place. Now, what happens if there is a change in the constitution? Anything
So
mentioned?
lordship, page 40, if your lordship sees page 40 of the petition, they have in fact informed about this thing, about the changes.
Ah.
And that has been recorded by the industrial department, industries department. That I'll have to fairly submit before your lordship.
Where?
That is the
Page
page
40.
40, your lordship says.
No, at that point of time, it was JD
It is
Chemicals.
JD Chemicals, then there is a recording in the handwritten thing, that like change of the unit to Jericho Chemicals to Jericho Chemicals. Then the name and style of, then the bottom lordship will find the JD, that has been like intimated.
Page 40
From
will
here, it
No,
looks
no,
like
that can be done.
that can
Now,
be
if
done.
that can be done, no, that is under the transport subsidy 71.
Yes, yes.
Now, can the same thing be done out here?
That is
How,
the-
how do you change the constitution?
Yes, they have only intimated that like that industrial, our constitution has, there is an application there. That our constitution has been changed from Jericho Chemicals to Jericho LLP. That has been, that they have informed. That much they have informed. Now, only thing, lordship, what I, in my opinion, lordship goes like that there was a precondition in the scheme that you'll have to be registered.
No, they were otherwise
That
registered under
they
the
were
company.
registered under TSS, but their conversion did not happen.
No, their conversion duly happened.
No, their
But it
conversion
still
happened.
happened and continued as a company.
No, the conversion happened in 2019. Order was passed by the industrial department only in 2019.
Huh.
Because they have to be first registered. Then they'll have to go for commercial production.
No, they don't have to register. The registration will
The
be done.
registration was under TSS. So that has to be changed to FSS.
Here it categorically says that the new, provided that it is otherwise eligible for so and so. Here it says, however, an industrial unit registered under TSS 71, which have not claimed subsidy under so and so, because they didn't claim.
That did not claim that.
Before the date of publication of the so and so, so they found in the official gazette will be covered under so and so, provided it is otherwise eligible for subsidy as per the provisions of so and so. So they will be automatically covered
No,
by.
so lordship, that is what, whether it's automatic or like
It's automatic.
they'll have to make an application of conversion, because all the process that industries department has followed, that there has to be an application for conversion.
No,
because-
no. Here it says will be covered.
No, that
Will
is-
be covered means it will be covered.
That was the interpretation, your lordship, the industries department, they followed that.
Your
followed-
industries department, they have rejected it on other grounds, saying that they were a company that was registered, not the LLP, but their claim is under the LLP.
No, that is
In the
one.
affidavit now they are taking the different ground.
And that's a different thing.
No, no,
But-
in
but
affidavit
if
they are taking.
But if we see
The
that
affidavit we have
particular
to-
document, Mr. Agarwal, if we see this particular document
I
at
have
page
seen,
80,
I have read.
their basic reason is something else.
Ah.
That you were not registered at that point of time.
As LLP.
You were only registered as a company. You were not registered as an LLP. And under such circumstances, that unit was not registered. That is what.
Yes, but that's-
All changes has been brought to the notice of the industry department. They have noted it, my lord, very.
And here the word is will be covered under so and so. That means it is an automatically.
Automatically.
You, on the basis that you are, but you have not claimed at that point of time, you are automatically covered.
Yeah, another thing, lordship, like that we have brought before your lordship, that the scheme is already over. The scheme has been withdrawn by the central government in 2016. And there is a notification which says that only those companies which have already been registered under the scheme, they will be only given the benefit of this. Because after 2016, there will be no more registration. So now the industries department has converted it is 2019. So that is also hit by actually their notification.
You don't need a conversion.
So that is the
It is a
conversion.
conversion being done by them on an application. That is a different thing. But the industries department also had said that the conversion is of 2012.
That registration was of 2000.
No, the conversion is also
No.
from 2017, page 78.
That has been given, lordship, I don't know how.
Is
it has
hereby
been given.
converted to registration under so and so as a new unit and allotted the registration of so and so issued on so and so. So this has been issued later on.
That this has been issued in 2019, and whether it can be done retrospectively.
Then what have you done with the director of industries? Huh? Are you saying that your officer is wrongly done it?
I can't go beyond
No,
this.
no.
lordship.
Are you saying it on affidavit that your industry, that the officer
No,
couldn't have done it?
we have not said so.
Then,
We
if
have-
you are not saying, then pay.
We haven't said so. We haven't said so. We are only saying that we in our affidavit.
Now what is required to be done? You will decide that issue. First of all, you need to submit something. You submit those things to the authorities concerned so that that limitation of this particular has to be given by
31/7/2000.
this 8th of May 2023
Yes, my lord, yes.
does not make the petitioner's entire thing infructuous.
That this
But when did you come into commercial production?
17.
Which, when?
27th.
So how could you have a claim prior to that?
No, the claim has been made. Period is, no.
No, here for the period up to 31/3.
I'm not this up to 31st. my lord,
You can never claim.
That
You
cannot
say
be
that
done.
you have also stated out here just now that you had the claim
yes.
after the commercial production.
It can be done after the commercial production only.
Then-
Before that, I cannot do it.
Then
Only
how
that
is
period,
this?
my lord, only that period. Lordship will kindly see.
No, how can you have it? You have not gone for commercial production at that point of time, as if for you.
Page 68. No, it is only for that period, my lord. 3 days or 4 days, whatever it may be. It's not we have claimed because the only period is 11/17, my lord. Your lordship will kindly-
Understood. We are only
68.
concerned, so we are only concerned with page 68.
68, my lord, for limited period we have claimed, not the entire.
No, only for page 68. Not for 1/4/2017, we are not concerned. Now, as regards page 68,
Yes.
when did you come for commercial production?
27/3/2017.
27th, that is the stated fact.
Then how do you get any transport subsidy prior to that?
Not, we are not seeking prior to, my lord. Your lordship will,
No, this-
what happened, my lord, may I just point out, my lord? Maybe your lordship, my lord, I have not been able to, my lord, the period is basically for 3 months. 1/1/2017 to 31. Now, my lord, this period they have mentioned, but we claim is your lordship only 50,000 rupees. If need be, my lord, I'll place, my lord, those documents before my lord to show It was not for the, prior to, because prior to commercial production, I'm not entitled to.
Therefore, if you have gone for commercial production, when did you go? 20,
27/3/2017.
27/3/2007.
23/7/3,
So how
2017.
can they get it from that? I mean.
No, wait. This particular document which is there as IA, in the IA, you have
Transport subsidy for the purpose of raw materials also, my lord. Your lordship will kindly see.
all pending CCIS claims pertaining to NAIP
Yes,
and
sir.
all claims for transport FS filed for the period up to 31/3.
Yes, madam.
So only up to 31/3 we are
Not beyond,
concerned.
not beyond.
No. Thereafter, this problem doesn't there.
No, therefore, the problem of the 8th of May, not later, there's no have any problem.
Has no problem out there. So it is only for the earlier period, brother.
Only.
You have only gone for transport subsidy only, your claim will be for which period? From 27/3 onwards.
27, my lord will kindly see. The movement of raw materials, your lordship will kindly see. I'm again coming to back, my lord, to the scheme. Page 41. Page 41 or no, page 41. Further. My lord will kindly see. The government will approve this, so is located in so and so for transportation of raw materials. My lord, page 41. My lord, production will be, my lord, thereafter. Transportation of raw materials and finished goods. So, my lord, the period prior to 31/7 or 27/3, my lord, is for the raw materials, my lord. And your lordship will kindly see the amount is only 50,000. And if need be, my lord, at 2, my lord, if your lordship gives me time, I think the bunch I can produce before my lord also. One by one. It will open. It is not only, my lord, only. Clause 7 is important. How much subsidy they will get and all that. Quantum of subsidy.
I'm not on that. I'm only on this.
Your lordship,
This-
my lord,
We have only page 68.
Yes.
Then page 68 is only of this amount. 50,383.
and then, my lord, that has been forwarded by the general manager, recommending, giving their recommendation.
Ah.
Your lordship will next page 68.
That is not the only document of only 50,383.
That is the amount we have claimed, because, my lord, commercial production, we have changed 27C. But for movement of raw materials, my lord, I am also entitled 90% of the subsidy. So, my lord, that claim,
So this is only on raw material, 50,000.
my lord, exactly, my lord, I can't say as on today, my lord, that is 50,000, but, my lord, raw materials has
No,
been
this is said for the entire period. It has been said for the raw materials.
raw material.
And the period, the entire period of the claim has been mentioned to be only from 1/1/2017 to 31/3. So we are only concerned at page 68, nothing else. So what is required to be done? They have to process it.
Let us process it, subject to the, my lord, outcome of the final outcome, or more. Lordship may dispose of, my lord, I have just come to my.
Not like this. You process it. Don't pay, just process.
So
it.
lordship, like apparently it looks like we in my humble submission, lordship, this as I have gone through the, as lordship has gone through the freight subsidy scheme, it should have been automatic conversion. It should have been from the language, but like the process they have been following is that like there has to be an application, and on the application they'll convert it. But the industrial department took a stand that because it was not converted prior to commercial production, so
No.
you won't get it.
Mr. Kulter, kindly tell me, when the scheme categorically mandates the mandate to him, which it is to be done, you have to do it in that way. If you have anything else which is the horse or is ultra vires, the scheme or that
No,
would
lordship,
not
I
be
can,
taken.
yes, lordship, I understood. Lordship, I cannot go.
Only thing we are concerned out here, just process this thing, don't make the payment, nothing to the effect. Because otherwise it will have the effect of the, all they are hereby convene the meeting SLC, if any pending, if any in respect of all pending CCS claims pertaining to women and all there for the period at the earliest to avoid undue delay in the matter. A report of
Otherwise, let's say, what I suggest that it can be disposed of by directing to the department that they will consider this matter and like process it. Because automatic conversion is there, let's say, that I have found out. It can be disposed of also. Because they cannot be stopped. Because since already TSS.
Yes, yes, Mr. Gugoi. Very difficult to recognize you without the mask. Yes. Come here.
Lordship, I am agree with the proposition made by my brother, Lordship. My lord may dispose of the matter on the basis of that the notification issued by the central government. In the Lordship miscellaneous application, it was annexed laws.
No, this is only for that period up till 31/3.
And petitioners claim also that, Lordship, as per page 68, Lordship. Page 68, Lordship. Page 68, he says that our recommendation for grant of freight subsidy on import of raw materials is given below for a period of 1 on 2017 to
So
31.
that is only for up till 31/3,
Lord-
but the
Lord-
petitioner has various other claims
Lordship,
as per the FSS.
Lordship,
Now the question as to whether it would be automatic or not,
Lordship,
I think that needs to be, further dealt with properly.
Lordship,
Don't you think so?
Lordship, Lordship. Lordship.
Yes, it will say that it
Lordship.
will be, but this will have a far-reaching consequences, not only in this matter, it
Lordship.
may on various other matters also.
Lordship.
So
Otherwise, Lordship, 17 is
there are
very.
two aspects of the matter.
Lordship,
One is as to whether it would be an automatic,
Lordship.
which prima facie this court thinks it
As
is
per-
automatic.
As per 17, Lordship, it should be Lordship.
Automatic.
Lordship.
And the second is how the constitution can be changed. As to, because they were all along
There is a.
registered as a company.
Company, Lordship,
The manufacturing unit was under the company.
company, Lordship.
Now thereupon it has been changed into an LLP. Now, if a change into an LLP happens, what is the effect on the subsidy schemes?
That
How
part-
can be, how is it taken care of?
that
There
part-
are various, this is a very vital aspect of the matter.
Otherwise also.
Because for that, not only this automatic, I have to decide that in order to take care of page 80.
Lordship,
Because page 80 is the reason
Lordship.
why they have denied it till now.
Lordship. They have denied because Lordship, it was under the Lordship company, Lordship. Because
Because
Lordship,
it was all under company, but not an LLP.
LLP, under LLP Act, Lordship, the
Now their registration is still under the company,
is still under a company.
but
Because
not under the LLP.
LLP,
Now, can there be a change in the constitution while enjoying the scheme?
Lordship.
That is an aspect which needs to be
Lordship have
looked
to
into.
decide it. Otherwise also the functions of the LLP members, it is not binding to other members, Lordship. Because Lordship, there should be in LLP, Lordship, they consist of, there may be constitution of 2 or 3 members also, Lordship. Then Lordship, one member's function, they cannot Lordship binding to other members. Unless and until it was Lordship, they have the authority, authorized. So that part Lordship have to
Now, what is the impact on a
Lordship.
change in the constitution?
Lordship,
That aspect, I think, Mr. Agarwal, you need to show me.
Lordship,
We'll take it up. You want it? We can take it up tomorrow. We can dispose it of tomorrow
Lordship.
after hearing on that aspect.
Tomorrow, Lordship, it will-
The first aspect, though, no problem, that can be taken care of, but this is a very vital aspect. Because let us assume you are a individual.
Yeah.
No, let's assume.
Yes.
You are an individual. Owning or being a proprietor of an industrial unit. You are enjoying a particular subsidy because this has not only on this, anything. Now tomorrow you form a company or a partnership where you bring this as an asset. Would that partnership firm be entitled to the benefit of the subsidy?
So they put in the shoes of the because earlier it was proprietor. Now it has changed its constitution to a partnership. Now whatever benefit the industrial unit was getting as a proprietor, in my humble submission, they will continue to get under the partnership.
No, it cannot be. It will have far-reaching consequences because now that means are you transferring? Can you transfer
No.
a proprietorship firm by bringing it out here in this manner? So you need to show me that how can a company be transferred to an LLP? And what is the impact on the LLP on that aspect?
Lordship, may I, Lordship?
Hmm.
Lordship, the page 64, Lordship will see
Hmm.
Government of India's, Industries and Commerce Department, Government of India has written to them,
Hmm.
recording the change of the structure from Jericho Chemicals Private Limited to Jericho Chemicals LLP, page 64.
Hmm.
So this has been issued to them.
A64.
So IEM has been changed.
What is this IAM?
This is entrepreneurs membership or something. Industrial membership.
Entrepreneurs membership industry.
Memorandum, yes, memorandum.
This memorandum.
Industrial Entrepreneurs Memorandum.
No, this is, I am directed to refer to your letter dated so and so
So-and-so.
on the above mentioned subject and say that the following correction, modification, amendments are made in the ministry's IEM acknowledgement number so and so dated so and so.
Yes, Lord.
What is this 7/6/2016?
Earlier, the acknowledgement was given.
The ministry had given an IEM acknowledgement. And what is the effect of this IEM acknowledgement?
The central government has accepted that. They have made the changes in the minority memorandum.
No, no, understood. But what is this IEM acknowledgement?
Lordship, may kindly come to page 66. There is an exhibit for IEM, filing of Industrial Entrepreneurs Memorandum.
Annexure 3.
No. List the matter again on, we'll have it on 2nd of August. List the matter again on 2nd of August. Full stop. In the meantime,
Lordship, it can be 3rd of August, Lordship.
not 3rd of August.
2nd of August, Lordship, I have some difficulties.
Do
3rd of August,
ask somebody else to appear
3rd of August, Lordship.
on 4th of, yes, 3rd of August.
3rd of August.
3rd of
Or 4th,
August.
no problem.
3rd of August, 2023, on which date an attempt shall be made to dispose of the instant writ petition. In the meantime, the respondent authorities, more particularly the Industries Department, shall take appropriate steps so that the so that the claim of the petitioner in respect to the freight subsidy for the period from 1/1/2017 to 31/3/2017 as enclosed as annexure as enclosed and as mentioned in the communication dated 21/2/2019 in at page 68 of the writ petition is not rendered infructuous in view of the communication dated 8/5/2023 issued by the Undersecretary to the Government of India, Ministry of Commerce and Industry, Department of Industrial Policy and Promotion. Okay, you take steps
Not so.
not to make it infructuous. Mr. Gogoi, you address this court on that, how a change, what is the impact on that?
And impact of the LLP was that part.
I accordingly stands disposed. In view of the order passed in the petition, the interlocutory application stands disposed. I gonna.
Right.
11,
Yes,
Your Lordship, respondent number 5 and 6 have filed an affidavit. Today, Lordship will have to respond to that.
Ms. P. Borgohai, the learned counsel appearing on behalf of the petitioner seeks for an accommodation of 4 weeks for filing and reply to the affidavit in opposition filed by the respondent number 5 and 6. Time granted in this the matter thereafter.
12,
Where pleases you, Lordship? Your Lordship, P. Nayak is on legs, Your Lordship. Kindly pass over the matter for time being, Your Lordship.
Who is on legs?
P. Nayak.
What is this matter about? It's the Ekegutta learning council.
Compassionate appoints-
Who has successful graduates committed that the entire work.
Relates to welfare municipal code.
Yes, no adjournment would be granted. Yes, tell me. What is your case?
No, Lordship, this RBR enterprise submitted their tender. RBR enterprise, the petitioner submitted their tender along with the private assessment 10 to 15 for different construction works under the Golf
The work I'm told has been already
Already been
completed.
completed.
Now what do you want?
Lordship, there is an observation in the order dated 33, Lordship, there is the order dated 33, 2000.
The contract work awarded in respect to the respondent are subject to the outcome of the requisition. This is only a pleasing order.
Lordship, order dated
I
30.
can't help it. The work has already been done. What do you want?
No, Lordship,
You want the money?
order dated 33, 23 may be seen, Lordship. 33, 3003.
33, 2023.
Lordship.
Yes. On considering the fact and apparently it has been submitted by the learned council as in this code that there will be a no bar in paying the bills of the contract work for which. Yes, then
Lordship, we submitted the tender in the name of RBR Enterprise, and RBR Enterprise, the proprietor is Sanjeev Kumar Rafa. Their contention from the Welfare Municipal Board that we did not submit the tender as a ST category farm. The farm is a ZNL one. That's why the earnest money that we have submitted 1% for the ST category tenderer. That is not acceptable. That is the primary ground of rejection of the tender. That's why the Honorable Court was pleased to call for the record whether the petitioner has submitted his ST certificate along with the tender paper.
but Mr. Dekar, what is to be done now? Once the work is done, what is to be done now? You can't help it
The
now.
petitioner can seek for compensation from the Welfare Municipal Board.
File a suit.
And that liberty may be given. That liberty, by giving that liberty.
Where is the judgment of Justice Supreme Court judgment, that judgment, what was that judgment? Where compensation was given, na? What was that? To file suit, civil suit?
So I'm not carrying that today.
The judgment pertaining to
Lordship will take up the matter after some time. I'm planning.
anyways, not necessary.
Yes.
It appears, it is stated at the bar that the work in respect to the notice inviting, the work in respect to the tender notice number GMB/15 FC oblique PT-2/2021/83 dated 29/1/2022 have already been completed pursuant to the tenders being pursuant to the work orders issued to the respondent numbers 10 to 15. The petitioner herein is agreed that the respondent Gwalpara Municipal Board have most illegally terminated rejected the petitioner's bid on the ground that the earnest money deposits so furnished by the proprietorship firm of Dhanjit alias Dhanjib Prasad Rabha, that is MSRBR Enterprise, was not by a ST, was not by a person belonging to the ST category. The learned counsel appearing on behalf of the petitioner submits that the proprietorship firm, that is MSRBR Enterprise, is a trade name of Mr. Sri Dhanjip alias Dhanjip Prasad Rabha, and it has no independent existence other than its proprietor. And as such, the security earnest money deposited in the name of MSRBR Enterprise ought to have been taken into consideration as a earnest money, EMD earnest money deposit by a person of the ST category. The learned counsel further submits that as the work has already been completed, nothing survives in the writ petition. However, on account of the illegal rejection, the petitioner is required to be compensated by the Gwalpara Municipal Board. Upon hearing the learned counsels for the parties and taking into account that the question of compensation will require adjudication of facts, which this court can't do in exercise of the powers under Article 2 to 6 of the Constitution. This court is of the opinion that the petitioner would be well advised to file a civil suit, file a suit before the competent court of jurisdiction, seeking the appropriate relief, seeking damages and compensation. Be that as it may, nothing otherwise survives in the instant writ petition, in as much as the work having already been completed. Accordingly, the instant writ petition, therefore, it stands closed as it has become infructuous. Before parting with the record, this court finds it relevant to observe that if the petitioner files a suit, the competent court of jurisdiction shall decide the same in accordance with law.
Deeply obliged. Obliged.
13.
Yes, what is this case?
My lord,
My lord, the rejection of my lord NRC.
Huh?
Rejection of NRC, my lord.
Your LRC has been rejected.
Yes, ma'am.
You don't have a LRC.
Yes, ma'am. My
Your name is
has
not there.
been Included. My name has not been included.
Why?
The same documents, my lord, my elder sister, my lord, kindly see page 54,
Hmm,
last page. Nomita Dev,
hmm.
by the same documents, my lord, she submitted before the, my lord, NRC authority.
Who is paying for NRC?
I am appearing for the NRC.
Yes, why have you not put his name?
Submissions made by my learned friend are not correct, Lordship. What has happened here is, Lordship, his claim is mainly based on paragraph 7 of his petition, where he says that the Srimati Namita Ghosh, this elder sister of the petitioner number 1, her name was included. And in fact, my instructions are, Lordship, that her name was wrongly included because she had submitted an order of the FT, an opinion of the FT. FT did not declare that she was an Indian, but wrongly it was recorded by the officer concerned. And that is how her name came. So there's a mistake committed by the officer, Lordship. But that ought not to happen. And in any case, Lordship, her parents were declared devoted.
Who?
This sister. So automatically it will not come.
What happened?
No, my lord, can you see, my lord?
Have you challenged that? Devoter business.
My lord, I don't know, my lord. I don't know that.
Then,
No, my lord, can you see?
if you have marked as a devoter out there, you should have said that, put it to the reference to the Foreigners Tribunal.
Let us not
There
do
are
that.
so many petitions filed in that manner. Why are you not doing it?
My lord, but
That your devoter has been wrongly marked.
my lord, one thing kindly see, my lord. The page 28, my lord, kindly see.
Are your parents alive?
No, my lord, they already died. In 2000.
And what, are you marked as a devoter?
Not, my lord, I have no, my lord, instruction regarding that. My lord,
No.
kindly see one thing.
No, Mr. Counsel. You are appearing before a court. You can't say that I have this instruction, that instruction I don't have. No, you have to find out.
Yes, my lord.
You have to come up and are you a devoter? Because your parents are.
My lord, kindly see one thing.
I won't see anything.
Page
You
28,
first
my
tell
lord.
me, Mr. Counsel, whether you are a devoter or not.
She was reading on my lord, in the school or in a school, Tangla Model High School on 9/2/1949, my lord. 9/2/1949, kindly see page 28, my lord. Annexure E. Annexure E, page 28, my lord, kindly see.
Annexure?
E, page 28, my lord.
Okay. Who has given this certificate?
Headmaster, my lord. Tangla Model High School.
Headmaster gave this certificate in 1989.
Yes, ma'am.
That your mother
Mother, yes, ma'am.
was studying in the year 1939.
49.
39, na? Has been reading in the school since 1939 and her date of birth is 9/2/1939.
Yes,
Given
yes,
in 1989 after 50 years.
yes, ma'am.
Why don't I ask the Registrar General out here to put a witness box there and ask this person to come and give evidence? First, tell me whether you are a devoter or not.
Lord, get instruction, I have not received.
You have to get your instructions.
My lord, what in as per voter list of my lord, 1989, my lord. Kindly see page 37, my lord.
Mr.
There is
Counsel,
no-
why? We are in 2023. Kindly come. There is a vote. Every year there is a voters revision. What is your present voters list?
Present voter list, my lord, 2019 and 22, my lord.
Yes. Where is your voters list? Yeah.
Yes, ma'am.
Page
Page
47.
41.
Huh?
Page 41, relevant portion 42, my lord.
Page 41.
They were opposed.
Okay. Name. Where's your name?
My lord, Harnakula 44, page 44. 854 serial number.
Where are you?
Devashish Ghosh.
Where
Devashish
your
Ghosh.
photo is there?
Yes, ma'am.
Where is it?
My lord, page 44.
Serial number?
854, 857.
854.
857. Page 44.
Devashish Ghosh. And 857.
Yes. 857, they were son of the, it's number one.
And who are the petitioners here?
Devashish and Devarup.
Devashish Ghosh and Devarup Ghosh.
Yes,
So they are the sons.
yes. Son of my lord, Sikta and Ghosh.
So you have not been marked as D. This happened when? This is of the voters list of
2019.
19.
my lord. Yes, thereafter, my lord,
So you are not a voter, D voter.
yes, my lord, but kindly see, my lord, is page 47, my lord. Relevant 48, my lord.
Now, what is happening, Mr. Architect Chaudhary? What is happening as regards those people who have not been done as per the NRC, not
Lordship,
included? How are you taking care of? Because
Lordship.
your appeal that FT did not happen.
That NRC, final NRC is yet to be. It's in a state of limbo, Lordship. It's not progressive.
Then what happened?
Because the case is also pending and it's not going anywhere in the Supreme Court.
Yes, Mr. Imtiaz Ali. What are where the orders passed in respect to these type of matters?
Lordship. On earlier occasion, your lordship, this court has directed when if the matter is pending or if it's related to NRC, your lordship, the appropriate forum is for the appeal to be filed as per section 8.
Where is the NRC rules?
Yes, sir.
Rule 7 or 8, there is a requirement, na?
Yes, your lordship. This is the.
Where is the requirement stating that they will issue a notice or something,
Yes, yes,
thereupon that will be final, and then only he will have a right to
Yes,
challenge it.
700, lordship.
Huh?
Citizenship, registration of citizen and issue of national identity card rule.
Give it to me. You challenge it then. Now your NRC is not final. Why you are fighting out
It
there?
is there, my lord, but my lord.
I give you the liberty. I give you the liberty, then you file. Because you see, what has happened is this, not here, not this claims and all that. Here. Publication. Publication, the local register so and so shall, after the disposal of the claims and objections on the survey, any person whose name does not appear in the draft national so and so published under so and so, the Iman file his claim along with so and so under Iman or in the additional list published in the Iman. Before the local refund. Registration will keep the list read the key. And now, what is happening as regards Rule 6? What is happening as regards Rule 6?
So far as claims are concerned, Lordship, those have already been considered. Now only the final list has to be published. After that, the appeals will, the rejection.
No, there is a authority before which he can approach. What is that? Have you constituted that authority?
Claims and objections have already been considered. That phase is over.
No. That is kindly see Rule 6. 6A. A person who does not come in the draft or in the additional can file a claim. See? Before a particular officer.
Yes.
What have you done?
No, Lordship, if his name is not there, Lordship, he has to make an claim for that.
Before whom?
That phase is already over.
No, no, that
Yeah,
over
yes,
is not
okay.
over. That is not over because the draft has come, then there is an additional list. Both
There is
have
an
come.
additional, yes.
Thereafter also he can, if he
Ah.
is aggrieved, he can come before this.
Yes, Lordship.
And that is why the FTs were made, the 200 FT or 300 FT, these people were appointed,
Hmm.
is because to take care of this situation.
You take this affidavit.
But the NRC having not been finalized, this is not happened.
Affidavit pending by the GC. Please. Lordship, may I take your lordship to the affidavit which has been filed by the deputy commissioner who is, deputy commissioner come.
Where is
district
the
elect-
affidavit? I don't have an affidavit here. What affidavit? আরে এখনো আজকাল কাগজ নামালে নাকি affidavit file করে? When did you file the affidavit?
It has been filed on 7th of September 2022.
Hmm.
September, yes, in fact, from this affidavit, lordship can make out, he has two different dates of birth. One in the petition, he has mentioned differently, in the NRC application, it is different. That apart, the parents' names are also differently noted down. And the NRC authorities have asked him to go for an hearing. His contention has been noted down and it has been recorded. Finally, the NRC authority will issue a rejection slip as per the procedure.
When?
That rejection slip is at present pending because Supreme Court matter is, because that is the reason.
So as of when that rejection slip is issued,
Yes,
then he gets a right under 6.
yes, there, then he gets.
I think there's a rejection slip, a right is there. One can approach the FT. That was the right where it was there.
Yes, any person not satisfied with the outcome of the decision of the claim and objections under paragraph 7 may prefer appeal before the designated tribunal.
That is FT.
8.
So now that rejection slip has not been issued.
Not been issued to
So
anyone.
then he can very well appear.
Yes,
out.
yes.
Give me that and the affidavit. I'll dispose it of.
Well, till then, some problems are.
What problem? Why
None-
says the NRC is
Well,
required?
The authority has not issued the, I cannot get my land mutated. Number one.
You need a NRC for a land
Yes, my lord.
mutation.
Yes, my lord, in the office, that is very much necessary, my lord.
No, is it required?
Yes, my lord, now it is required, my lord. And in.
Where? Tell me, where is it required? That you require NRC,
Get-
and when the
get the
NRC
land
has
of
not
any-
been made final, the government is saying the NRC is
In
not
case of this,
final.
my lord, those, my lord, whose name is not included in an NRC, my lord. For them, my lord, it is necessary.
Is it?
Yes, my lord. And number two, my lord, for issuance of any, my lord, passport, my lord, it is necessary, my lord.
Passport, don't tell me NRC is required. I know other things, but
No, no,
passport, don't tell me NRC is required. Don't make that submission, Mr. Council. Passport, show me. Don't make this unnecessary submission. You require those other documents, we will have it. Then NRC name is not there. Where is the rejection slip has not been given out there?
Since I have not been,
Have you mentioned it in your affidavit?
no.
Then why are you making these submissions for land sale you need here?
My lord, after all, I may be treated as an Indian citizen till, my lord, till, my lord.
Who said that you are not an Indian
Rejection of.
citizen?
my lord.
Who has stated that you are not an Indian citizen?
My
They are
lord,
not saying that Indian citizen is not there. They have not issued the rejection slip even.
Yes.
So the matter is pending.
Yes.
And the Supreme Court now is taking up the matter. NRC is still taking it and there is not finalized. And the government is against this NRC.
Yes.
So NRC goes, then all petitions will become infructuous. So let me first dispose it of. Yeah.
My lord, but the great, my lord, kindly, my prayer, my lord, and D should be considered.
What prayer?
Directing the respondent to treat the petitioner as citizen of
Huh?
India.
Prayer?
D. Page
To
17.
treat the petitioner as a citizen of India.
Yes, my lord, that one.
That
is,
I
my lord,
can't.
No.
Sorry. I am not
My lord,
passing
please.
anything. I am not here to hear. You see, these aspects, should I say, that these aspects are matters of disputed questions of facts, I'm not going to do it, dismiss it on that ground. You want that? You take the order which I am giving it. Take a seat.
My lord, tell you one thing, my lord, consider.
Hmm.
My lord, consider one thing, my lord. Since our lands, my lord, has we cannot get mutated our land in absence of this, my lord.
NRC rejection.
Yes, it is happening in the,
NRC rejection has not happened. The NRC, I'm recording it from their affidavit that they have not issued the rejection slip.
yes.
Says your claim for NRC is pending. So then, there's no
Then, my lord,
rejection.
till then some. My
You
lord,
want to buy land.
my lord, till then.
Don't buy land.
My mutation, my process of mutation of my land, my lord.
Where is it? Where is it? The mutation, who has not done it to you? On account of NRC.
Authority, my
Show
lord.
me, where is your statement here?
I have not stated, my lord, what is.
Mr. Counsel, what is your name?
R.H. Chauhan.
R.S. Chauhan. Very well. Write it in bold letters. The petitioners herein have approached this court challenging, where is that, 14/8/2018, where? Challenging what? What are you
51.
challenging? Huh?
51, my lord.
Challenging 51?
50 is the, my lord,
50.
50. Reason for non-inclusion in the NRC.
Challenging the communication dated, what is the date?
Wait, my lord, left side.
14.
14/8/18.
Date is?
14/8/18.
Down below.
Down there.
Challenging the communication. This is you have written. What is this? This you have written.
My lord,
This is an application you have written asking for reasons.
Yes.
That is it.
Yes.
Why you are challenging this? The petitioner here, both the petitioners herein have approached this court by filing the present with petition, being aggrieved by non-inclusion of their name in the NRC. From a perusal of the petition, it transpires that the petitioners claim to be Indian citizens However, the respondent authorities, more particularly the respondent authorities, more particularly the respondent number 4, have illegally and arbitrarily not included the names of the petitioners in the NRC. This court had issued notice the Deputy Commissioner come District Election Officer come Electoral Registration Officer Udalguri had filed an affidavit in opposition. In the said affidavit in opposition, the various claims so made by the petitioner in the writ petition have been disputed. Be that as it may, it is however relevant to take note of that the petitioners were asked by the NRC authorities to appear before them in various locations The petitioners were duly heard. The case of the petitioners claiming to be inserted in the inclusion, claiming to be inserted, for claiming their names to be included in the NRC have also been stated, is yet to be decided. It is further mentioned that if the claim of the petitioners are decided against the petitioners, rejection slips shall be issued by the.
But that authority name I am unable to find out because that before the NRC authority, it has been mentioned. That is the authority which has been constituted.
By the authorities concerned, and thereupon the petitioner would have a right under section 8, rule 8 of that rules, what is the name?
Clause, it is before the law.
Book is
Clause.
before your-
Huh?
book is before your last.
Book is not, rule 8 of the
Clause it,
Clause.
citizenship,
Registration.
registration of citizens and issue of national identity cards, rules 2003. It has also been stated in the said affidavit that the state authorities have also not decided the issue pertaining to the inclusion of the name of the petitioners on account of the matter pertaining to the NRC being pending before the Supreme Court. Upon perusal of the said affidavit and taking into account the materials on record and hearing the parties, this court is of the opinion that as the matter pertaining to the inclusion of the petitioners in the NRC is presently pending before the authorities, and the said authorities have not taken a decision on the matter on account of the matter pending before the Supreme Court, the reliefs which have been sought for in the writ petition cannot be granted. It is, however, observed that if the application of the petitioner petitioners seeking inclusion in the NRC is rejected, the petitioner can very well challenge the same in terms with Rule 8 of the rules of 2003. This court also finds it relevant to observe that as the matter pertaining to the inclusion of the petitioner's name in the NRC is sub judice before the authorities, no prejudicial steps be taken against the petitioners on account of their names being not included in the NRC. With the above, the petition stands disposed of. You got more than what you should have. Yeah.
Yeah, sorry, Lordship, but timing this time. The matter was mentioned this morning, Lordship. The bench for matter was mentioned this morning, Lordship. In court number 3, presuming that Lordship is the senior of the bench for matter. Lordship. Now, Lordship, when I'm pursuing the matter, the delineation informed me that this matter will not come because this is a matter of 2023, and you have mentioned in the court number 3 instead of court number 7. So, Lordship, the urgency is there if possible, Lordship, tomorrow, Lordship,
Which one?
this matter.
Tomorrow? Why?
Lordship, some urgency is there, Lordship. It was fixed on today, Lordship. Monday it was taken up, Lordship, but opposition was not there, so Lordship, court fixed today. But
What is the matter about?
matter of Lordship, a notice was issued, Lordship, to sell the key state of this petitioner, Lordship.
Huh?
Key state of this, to sell the key state of this petitioner.
Sell the key state of the petitioner.
Lordship.
Then
Then Lordship, we are selling that notification.
who wants to sell the key state of the petitioner?
Petitioner's company, Lordship. Petitioner's company. It's a company,
Petitioner company wants to sell the key state.
government wants to sell.
The government wants to sell the key state. And
And this petitioner is selling that notification.
who are the petitioners?
It's a company, Lordship, that entire properties belong to this company, Lordship. Due to default of Lordship, provident fund, Lordship, they have issued notification to self proclamation. So urgency is Lordship, possible tomorrow, Lordship.
Not when is the Friday? Friday.
Friday, Lordship.
Time being item 56.
Yes, Mr. Sutia. Now, what about this? The petitioners?
Well, they cannot specify the name of the persons, my lord, who are, my lord, displaced, my lord.
My lord, I want to submit something.
You have been evicted?
My lord.
Have you been evicted or not?
Not evicted, my lord. Not evicted. It is confirmed. Legally.
So what is your right?
My
to
lord,
remain?
my lord, some paddy fields are they are occupied. Some paddy fields are not mine.
No. What is your right to remain in the government land?
Yes, my lord. Admittedly, the land is located within the boundary of Nagaon district, my lord. And admittedly, the DC, it is admitted that about 60,000 voters in a disputed area under Ujal LSC, my lord. And the eviction drive by Kabianglom defying their boundary, but it is not.
Mr. Counsel, where have you stated which area you have been in occupation?
In a circuit gosti, my lord.
Where? Because I am not going to stay that impugn notice of 27/6. No. Neither this court is going to do anything.
Within the specified number to satisfy.
Tell me which area you are in possession.
I am in possession in Saket Bosti Milo.
Where?
Saket Bosti Milo.
What is this Sarke Bosti?
It is under
Nakuti number 2.
no Kuti.
N
No Kuti Milo.
NK Sarkar Bosti,
Yeah.
Moza, PS Lamding,
Yes.
District Nogam.
No, no. This is
So you are not, your action does not fall within the Karbi Anglong.
not.
That's it.
Yeah.
Okay. Who is appearing for the deputy commissioner here? Nogam?
I'm a trainer.
Yes, what is your stand?
This will start receiving instruction. They don't tell you, they don't look at it. Instruction yes. Please continue. They are not conclusers, they are not the land. Like, it first most out. They are
So these no information typed out as annexure 9 is only in respect to Karbi Anglong.
Karbi Anglong, we say autonomous county is.
No, it is only Karbi Anglong,
Yes,
not by Nogam, but you are at Nogam.
yes, yeah, I am not by eviction, drive was stopped. At the instance of the Nogam administration on that day, my lord. Why they protect us? Because we are under the Nogam administration, my lord. I called the office of the SDO, and on the date of eviction, my lord, at the instance of administration of Nogam, from Hujai, they reached the spot and they stopped the eviction time. And this issue is pending before the state level, my lord. Before the state, my lord. State respondents, my lord. We have no objection. We have no objection if the eviction drive is made by the Nogam administration. But by encroaching from other districts,
So your case is that.
that man. We are protected because of the administration of Nogam district.
The Nogam administration is protecting you.
Yes, man.
Is it?
I have the instruction.
Chalo. Issue notice, making it returnable on where, how long?
2 weeks.
Hmm?
2 weeks.
Oh. Issue notice, making it returnable on 21st of August, 2023. Mr. J. Sutia appears on behalf of the respondent numbers
6 and 8.
6 and 8. Mr. N. Gusami appears on behalf of the respondent numbers
1, 4, 5.
1, 4, 5, 7, and 9. P.R. Mohanto appears on behalf of the respondent number 1, 2, and 3. So, as the respondents are duly represented, extra copies of the petition be served upon them by 28th of August, July 2023. 2/8. The case of the petitioner here is that the petitioner, along with others, had initially filed a writ petition challenging an eviction drive carried out by the Karbi Anglong district authorities without issuing any notice, and many of the houses were demolished in the said eviction drive. The said writ petition was registered and numbered as WPC number 1584/2019. This court, by an order dated 8/3/2019, had directed listing of the said writ petition on 23/2019. And the respondents were directed not to undertake any further eviction operation. It has been submitted by the learned counsel appearing on behalf of the petitioner that in the meantime, the said interim order was continued. Full stop. On 26/6/2023, when a matter came up before this court, when the writ petition being WPC number 1584/2019 was listed before this court, the counsel appearing on behalf of the petitioner, taking into account the present land policy of 2019, withdrew the said writ petition with the liberty to approach the respondent authorities for seeking settlement / allotment of the land in question. Immediately on the next date, on 27/6/2023, the respondent authorities in the, that is the respondent number 6 and 8, initiated steps for eviction by issuing an information which have been enclosed as annexure 9 to the writ petition. The petitioner thereupon submitted. No. Who submitted this?
It is submitted by the GP president and AP members.
Thereupon, you did not submit.
The president of GP Milo
Okay.
and AP also, members of AP.
Thereupon, the petitioner, the president of what GP?
Yes, ma'am.
What is this GP?
Not, it is the original.
Thereupon, a representation was submitted to the office of the subdivisional officer Hojai, Sankardev Nagar. Requesting the said authority that a Lat Mandal bracket survey team be deputed by the Hosai district administration so that the boundary line can be surveyed. Inasmuch as it is the case of the petitioners herein that the land on which they are possessing falls within the district of Nagaon. Today, when the matter has been taken up, Mr. J. Chutier, the learned counsel appearing on behalf of the respondent number 6 and 8, submitted an instruction dated 26/7, had submitted an instruction issued by the divisional, what is that? Forest officer, Karbi Anglong District Council, Karbi Anglong West Division, wherein it has been mentioned that eviction drive was carried out under Langkaijan USF area and Kludung, KLUR, Kludung, USF area under the West Karbi Anglong Division, under the Karbi Anglong West Division, The said eviction drive was carried out on 11/7/2023 after consultation with the Hosai District Administration and the officials of the land survey. It was further mentioned that during the eviction, during the eviction process in Longkaisan, USF, 233 numbers of houses were evicted, corresponding to an area of land measuring 6.8 square kilometers, bracket 5,100 bighas, whereby 1,165 persons were displaced. In respect to Kurlung, USF, 14 houses were evicted, corresponding to 70 bighas of land, whereby 110 people were displaced. It was further mentioned that 15 numbers of houses were left at Ambari area due to border dispute, and the same will be evicted in consultation with the Hosai District Administration and the officials of the Director Land Record in due time. The said instruction is kept on record and marked with the letter X. Mr. A.K. Datta, the learned counsel appearing on behalf of the petitioner, submits that on account of the timely intervention of the Hosai District Administration, the petitioners have not yet been evicted, taking into account that the land where they are occupying falls within the Nagaon district. The issue therefore arises herein as to whether the Karbi Anglong officials, as to whether the respondent number 6 and 8 would have the jurisdiction for eviction in respect to areas which falls within the jurisdiction of the Hosai administration. Taking into account the above, this court is of the opinion that the interest of justice would be met if that the respondent authorities met, thereby restraining the respondent number 6 and 8 from carrying out any eviction proceedings in the area falling within the Hosai District Administration till the next returnable date. The Deputy Commissioner Nagaon, as well as the Subdivisional Officer Hosai, shall apprise this court about the stand of the said authorities in respect to the eviction drive on the next returnable date.
Timing item 2.
This case, I have taken Talabana to the respondent 2 and 4.
Alabana done, register ready.
Yes, yes. Go.
Okay. The learned counsel appearing on behalf of the petitioner submits that he has duly taken steps upon the respondent number 3 and 4. Taking into account the above, list the matter after the completion of the service upon the respondent number 3 and 4.
one more receipt, we have received an item number 52 and 53. The same earlier from transfer from the internal bank. So same.
You have some personal problems to go home? Then sit down.
Okay.
Production list item number 1.
My landlord, then Mr. Ladha has come from Mumbai.
Yes.
Hey, please, your lordship.
Yes.
Your lordship, the issue pertains to levy of education cess in respect of industries which are exempt from excise duty. The whole issue has been decided by this honorable court, by the learned single judge, as well as by the division bench.
Hmm.
The decisions were cited before the authority. He has quoted those decisions and still not chosen to follow them. That is one aspect of the matter. The whole issue now has been decided by the Honorable Supreme Court about 3 weeks ago. May I just hand over that order of the Supreme Court, but before that, a set of 3 judgments I'm just submitting before my lords.
You are challenging?
Before I take your lordship to the Supreme Court order, may I
No.
just give a brief background of the whole matter, your lordship.
Mr. Counsel, what are you challenging here?
I am challenging the order of the Assistant Commissioner.
Dated 31/3/2023.
Yes, your lordship, at page 245 onwards.
363?
245, your lordship. There are 4 orders, your lordship. The 363 also would be one of the orders.
Okay.
He has passed 4 different orders
Okay.
for 4 different periods. May I give the lordship a brief background before
Yes,
I
yes.
come to the judgment, your lordship? Lordship, in 1907, the industrial policy was declared for the state of, for the Northeast area, where 10 years exemption was granted from excise duty and income tax for a period of 10 years to new industry and for substantial exemption. The same policy was extended in 2007 for yet another 10 years. In 2004, so we set up the industry was there, exemption was granted. In 2004, education cess was levied, which is a kind of an excise duty, which was a piggyback tax to be payable by all others as a 2% of the excise duty levied and collected. Since in Northeast, there is no levied and collection of excise duty, the question of charge of cess does not arise. This matter went up to Supreme Court, and in case of SRD nutrients, the Supreme Court held that yes, if the excise duty is exempt, there is no question of charging of excise cess. Cess was ordered to be refunded. 2 years after this judgment of the Supreme Court, so I got a refund order, refunds were sanctioned. To all the industries in the Northeast, refunds were sanctioned. 2 years later, 2019, another bench of Supreme Court, not concerning our matter or any other matter, held that in case of cess, a separate exemption notification would be necessary. Before SRD nutrients, the another judgment of the Supreme Court was not cited, and therefore this is a per incuriam judgment. So the question arose, what happens to those which have already been granted in terms of SRD nutrients? The government, so SRD nutrients case moved for review. Review was rejected by the court. So SRD nutrients became final and refunds were all given to everybody. They moved another application sometime in 2021, asking for variation of that order of SRD nutrients, and which application was ordered to be referred to a 3-judge bench of the Supreme Court. Still pending, not yet referred. In the meantime, the question whether those refunds which have been granted are erroneous refunds or not on 11A came up for consideration. This honorable court held rightly that section 11A permits you to call for only erroneous refunds. Refunds granted in pursuance of a Supreme Court judgment
is not an erroneous refund. Therefore, show cause notices itself were quietly certified. That was the top sem judgment. The first judgment, Your Lordship, pre-judgment judgment. The first judgment is the top sem judgment. Para 52, if Your Lordship will turn to, just I refer to only 2-3 paras and 4 lines. Para 52. They deal with 11A, whether this is erroneous, and come to the conclusion that no, what you can recover is only erroneous refunds. This is not an erroneous refund, and therefore there is no question about it. And para 68, Your Lordship. The refunds were validly granted, and your show cause notice itself. Can I just read 4 lines of para 68, my Lord? In view of the above discussion, the court holds that the refunds granted sanctioned earlier in terms of the judgment of the apex court rendered in SRD nutrients, as well as in terms of order passed by this court directing such refund of education cess, cannot be revoked collaterally by a quasi-judicial authority of the department without taking recourse to the statutory and/or judicial remedies available. In view of dismissal of the earlier review petition filed by the department against the judgment of the apex court in SRD nutrients, and also in view that no appeal or review having been preferred against orders of the court directing entitlement, the judgment of the apex court in Unicorn holding SRD nutrients to be per incurium will not permit the department to unilaterally revoke or reopen the issue without taking recourse to the remedies available to them before a judicial forum. Such actions initiated by issuance of the impugned show cause notice, if permitted, will amount to revoking the earlier orders passed by the department officer exercising quasi-judicial power unilaterally, and which cannot be permitted. And the last, Your Lordship, the show cause notices itself were held to be without jurisdiction, para 72. In view of the above matter, the show cause notices issued are required to be held to have been issued without any jurisdiction and by wrong interpretation of the powers under 11A, read with 11AA, and therefore the same are required to be satisfied. So the show cause notice itself were held to be without jurisdiction, etc. This was taken in appeal before the division bench of this court, second judgment, Fishery Industries. Justice Tully and Justice Pathak's judgment. Para 33, 34, 35, where this is completely affirmed. Para 33, 34, 35.
Yes.
Approving top sem, and then holding that we agree with the submissions of the learned counsel to the SSC, and that this was not refunded erroneously. In the consequence, the appeal filed by the revenue is dismissed. This has been affirmed by the division bench. Department chose not to file appeal against this judgment to the Supreme Court, which AC also noted. In the meantime, Your Lordship, the matter traveled from Jammu and Kashmir High Court. Similar matter, it's Saraswati Agro. Short order, Your Lordship, passed about 3 weeks ago, a week after I filed this petition here. 4th of July order of Justice Nagaratna and P.K. Mishra, Your Lordship. May I read the short order?
Yes.
We have heard so and so. He pointed out that this court, in this case of SRD nutrients, reported in so and so, gave a ruling contrary to the judgment previously rendered by a 3-judge bench of this court in Modi Rubber. In a subsequent decision, namely Unicorn, the judgment passed in SRD nutrients was overruled, and it was held that the exemption from payment of excise duty under a notification granted would not exempt the payment of education cess and secondary education cess. It was also observed in the said judgment that judgment passed in SRD nutrients was per incurium. learned ASG during the course of submissions has brought to our attention an order passed on 7th September 21, referring to the very decision passed in SRD nutrients, which has been overruled to a larger bench, having regard to the fact that the said decision was per inferium in as much as it had not considered the earlier judgment in Modi Rubber. Therefore, he submitted that this matter has to be connected with the said matter and the judgment to be passed in line with Unicorn. We have given our anxious consideration to the submissions made by the learned ASG in light of what has been stated by the High Court in para 74 of the impugned judgment. Quoted later here. In SRD nutrients, it was held that when payment of excise duty is exempt under Central Excise Act, then the 2% education cess and secondary and higher education cess payable on the aggregate duties of excise will also be exempted. However, later in the case of Unicorn, reported in so and so, the aforesaid judgment of SRD nutrients was overruled. And it was held that although the exemption from payment of excise duty under a notification is granted, there is no exemption from payment of education cess. Therefore, the SSE who had paid the excise duty and education cess was not entitled to a refund of the education cess which had been paid. Also, where refund had been paid pursuant to the judgment in SRD was no longer valid. With regard to the reference order made on so and so on a miscellaneous application filed by the revenue seeking to undo the judgment in SRD, which was overruled in the subsequent judgment of this court in this, the question is whether there was a need at all to refer the matter to a larger bench. This is for two reasons. Firstly, such an application could not have been filed after a review petition in SRD has been dismissed by this court. Thus, in substance, by filing the miscellaneous application, the revenue was seeking a second review of the said judgment, which is impermissible in law, Order 47, Rule 9, CPC. Secondly, by ignoring the explanation to Order 47, Rule 1 of the CPC and the principle that emerges from the same, what is sought to be contended by learned ASG is that if a judgment is overruled by this court by a subsequent judgment, then the overruled judgment will have to be reopened, and on reopening the said judgment will have to be brought in line with the subsequent judgment, which had overruled it. This is not permissible in law for two reasons. Firstly, there has to be finality in litigation, and that is in the interest of state. Secondly, a person cannot be vexed twice. This is epitomized by the following maxims. Three maxims quoted, Your Lordship. These maxims would indicate that there must be an end to litigation. Otherwise, the rights of persons would be in an endless confusion, and fluid and justice would suffer. That is why the explanation in Order 47, Rule 1, which is a wholesome provision, has been inserted in the Code of Civil Procedure. It states that once there is a subsequent judgment overruling an earlier judgment on a point of law, the earlier judgment cannot be reopened or reviewed on the basis of a subsequent judgment. The contention of the revenue is that in view of the subsequent judgment of this court in Unicorn, the recoveries could be made from the SSE with regard to the refund of education cess made by the department, or if not paid by the SSE following the judgment in SRD. In the above circumstances, appeals were filed before the High Court by the SSE. In the instance case, the High Court raised the following question, and then para 74 of the High Court order, which has been fully affirmed. In substance, the High Court, do I read the para 74?
Whether the SSC is liable to return the education cess on the changed view of law as subsequently.
Yes. So in substance, the High Court has stated that the decision in SRD nutrients has attained finality and was binding on the parties there. Therefore, the subsequent decision of this court overruling SRD in Unicorn cannot have a bearing on past decisions which had attained finality, although they had followed SRD nutrients, which was subsequently overruled in Unicorn. Otherwise, a Pandora's box would be opened and there will be no end to litigation which is against public policy. This is exactly what is sought to be done by the reference order dated 27 September 21. When we read the reference order in light of what has been discussed, we find that the reference order was unnecessary. In the circumstances, the SLPs are dismissed, pending application for any shall explain. So therefore, a quietus has been given to the whole issue now by the Honorable Supreme. My respectful submission is, I have the single judge, the division bench, now the Supreme Court. The same order should apply to me. And maybe Your Lordship would like to say a word about the conduct of the officials here who refuse to follow the judgment of the single judge and the division bench on the issue. And they themselves note that no appeal is filed to Supreme
So
Court.
you got your refunds on the basis of the SRT.
Yes, Your Lordship.
Now, after that,
They
that
raised
was
the
for
show.
that period. And now they are open, they have opened up the assessments.
They issued show cause notices. Many assessees challenge the show cause notices itself. And those are the judgments of Topsem and Fishery. I replied, because Your Lordship at times says it's only a show cause, why don't you reply? So I replied. In reply, then he held back and then he passed these orders again. By which time Topsem had come, Fishery had come, which I cited, and I said nothing survived. He still confirms the demand mechanically, Your Lordship. With great respect, I said, it's order was accepted.
Lordship, I am on behalf of SPKL. So today also he could not come to the court due to his leg injury, Your Lordship. But since the orders are not annexed in the petition, I could not go through, Your Lordship. I leave it to Your Lordship. Your Lordship, please.
The council will take it up tomorrow. This is an unlisted matter.
Yes.
Please, Your Lordship.
We'll take it up tomorrow. And the first hour, 10:30.
Very
You're
good.
leaving at what time?
Very good. No, I'll be here in the evening, Your Lordship. I'll come for this matter. I'll do this matter.
Okay, tomorrow we'll take it up at
Grateful,
10:30.
Your Lordship.
I'll pass the order. Let her go through it.
Fair, fair. Your Lordship. Deeply obliged.
In fact, this particular issue has already been settled by Justice Rumapal's judgment in BSNL
Yes, Your Lordship.
2006, I think
right.
4 SCC page 1,
That's right.
where the issue has already been settled.
They were
That
also-
once it attains finality in so far as this, any other judgment which come could be only means if an order has been passed and there has been no challenge, a reference has been made in respect to that state question, that might take into account other aspects of the, but you cannot touch on what has attained finality.
Absolutely. Your Lordship, this has all been also cited in Fishery.
Huh?
All BSNL judgment
Yeah.
has also been, I did not want to take my
Yeah.
lord's time because the Supreme Court has already decided the matter now. But in Fishery division bench, Justice Dhulia has also exactly referred to what my lord just mentioned.
Okay.
About BSNL judgment of Rumapal.
Because that is the basic
That's
idea
the basic.
behind it.
Absolutely.
Chalo. The learned counsel for the petitioner have been heard at length. Mr. So appearing on behalf of the central government,
Central Excise, Your Lordship.
Central Excise Authorities. Seeks for an accommodation to go through the orders orders impugned in the instant proceedings. List the matter at 10:30 tomorrow.
Gratefully obliged.
Yes, Mr. Manik. Yeah, matter. Something is wrong with my.
What are some section or two?
My lord, this case pertains to an issue which we have been canvassing since December 2020. A particular fishery was settled with us. I'm totaling to 1 crore 58 and odd for 7 years, annually being 22 lakhs odd. The day we got the possession, from the next day onwards, we wrote to the authorities, that's at page 40 to 54. I would not trouble the lordship, that it falls within the territorial boundary of the Missing Autonomous Council, and people from that.
Hey, Hunokson, man, Abbas you. Something is wrong, seriously. All these people. Abbas, man, dictate. Yes.
If I rephrase my submission again.
What are you asking for?
Well, may I just give the background to that, 2 lines.
We'll hear about the background. Let us see the relief.
There's an admission by the authorities at page 123 and 126.
Communication so far as the same directs the Deputy Commissioner on the aspect of steps for recovery of the outstanding dues from the petitioner.
I challenge the demand
notice
on grounds of
dated so and so
123,
issued by
126.
so and so. Okay. Now this is of 12/7 and 17/7. Where is the 12/7?
Lordship is referring to.
12/7. Yes,
126. May I read 126 for the
yeah,
moment, Your Honor?
regarding the alleged encroachment of so and so and
If Lordship had come to 127, the operative part, it gives a cue to
of the
that.
above, you are requested to take follow-up action.
Definitely.
Written to the deputy commissioner, take steps for removal of illegal encroachment by the missing people. In general, excluding any settlement order issued by the MHC as said it is not pending with the. Because another report is submitted on the status of total use of revenue from the date of handling over in 2020. Amounts so far deposited and outstanding on each step taken for recovery of such.
If Lordship takes 123 also, there's an affirmation by the authorities concerned. They've identified the police station and the outpost under which the action is taking place.
You are directed to deposit the outstanding amount of the. Yes,
What I am on, Miller,
yes.
if an area of ABCD is settled with me, I am bound by law to pay the revenue. There is nothing for me, except under fishery rules if something comes up. Now, when there's an admittedly encroachment of a major part, which 123 also says, you cannot saddle me with that revenue. I am entitled to free possession. Kindly re-estimate the revenue.
Where is it stated at 123?
123. If I just read it out,
Who has written this letter?
this is by the police authorities, Miller.
Yes, what does it say?
With reference to the subject cited above, I have the honor to report that as per government order so-and-so dated 18/11/20 and by this office order so-and-so 5/12/20, Sri Prafulla Hazarika, secretary of so-and-so is allowed to operate the Dihing Part 1 fishery for 7 years with effect from 5/12/20. But he alleged that some members of the MSC are preventing them from collecting fishery revenue. I have inquiry about the illegal fishing and collecting of revenue and preventing the member of the Dihing Part 1 fishery from revenue collection of the boundary of the Dihing Part 1 fishery by missing autonomous council, and it is true. This point.
Then?
I have my lord, they are not allowing us to operate. This is
No,
what
no, you did not say that. No, I have contacted many times.
No, no, this is
members
true.
of who collect the.
The inquiry part is true.
from legal documents and nutrients.
And they told me that the MSC gave permission them to collect revenue, but they could not produce any documents which related to the revenue collection.
Then
Sri Prafulla Hazarika so-and-so Dibrugarh stated before me that most of the fish of the revenue is collected from the west side of Brahmaputra River part from so-and-so, but the said side is occupied by the MSC and they continue to collecting the revenue from that side. The west side of Brahmaputra River so-and-so is a fishery from where the MSC illegally collecting the revenue is given. They identified a post.
Fantastic.
And there's also an order from this honorable court at page 83.
83 is what?
83 is we challenge the jurisdiction of the missing autonomous council to make random settlements of 60%, 40% fishery or under the AFBC, even if it's falls within territorial area. So this honorable court, while issuing notice at page 86, was pleased to pass an interim order. If I may read
Then
that.
what have you done pursuant to this letter on 17th of July? What have you done? Have you asked them to allow you that during this period, give us some
This
remission or something?
This
to the effect?
aspect has been litigated since long. Earlier, it was in the realm of dispute. There's an interim order in earlier writ petition, no course of action be taken. There's an interim order in another writ petition, do not the status quo with regard to possession. There's a direction by this honorable court on an earlier writ petition that some old statements are being made in paragraph 14 of a particular writ petition. Get back with the instructions. They do not. They keep in the realm of a thing that some things is cloudy. Now they admit. Once they admit, we also admit that we have to pay, but pay to the extent you allow us to operate.
How much?
Let them revisit me. Lord.
No, how much?
I cannot, as a lawyer, calculate that. Let them
No. I'm not asking Mr. Bonik to calculate. I'm asking the secretary of this particular the Part 1 Fishery Cooperative Society Limited to calculate.
Very well.
How much?
If I may indicate one thing,
Yeah.
If I may indicate one thing, Lordship takes up 83 for a moment. The operative at 86.
I've seen it. Tell me.
86 part. In the interim until further order from the court, the respondents and the missing autonomous council shall neither settle nor hand over possession of any water body of 60%, 40% category of the fishery department of the state, as well as the Assam Fisheries Development Corporation that falls within territorial jurisdiction of the missing autonomous council, including that part of the Part 1 fishery of Dibrugarh from Bhekuri Sapuri to Itakuli Gaon of the MSC, and further shall not disturb fishing activity of the lessee with whom such water body is settled by the concerned authority, even though the entire area and or part of the area of the water body falls under the territorial jurisdiction of the state council. Now, a direction is there, do not do it. Now the government admits it is being done. Well, 21.
Who admits?
The government?
No, the
May I read?
SI does.
My lord, Chair.
The SI does, the police official.
May I travel over to page 126? 127. Take immediate steps for removal of illegal encroachment. They're not disputing it. Take immediate steps for removal of illegal encroachment by the missing people in the general, excluding settlement order issued by MSC. Now, this is contrary to 83 again.
Take immediate steps for removal of illegal encroachment by the missing people.
And what the SI says after inquiry?
In general, excluding any settlement order issued by MSC.
I am precisely on that.
Yes.
If MSC has issued any settlement order, page 83 says MSC do not settle anything.
No. But the page 86 does not nullify a settlement which has already been done.
My
Does
lord,
it?
Page,
By an interim order, are you saying that the MSC settlement order has been
my lordship,
if any settlement?
the crux of the matter at page
Let
86.
us, have you made the missing autonomous?
No, I
council?
don't want a missing autonomous
Yeah.
council.
What is this?
My lord, for this,
You are making all these allegations
I
again.
don't know.
That's
in this writ
a
petition,
petition requires to be dismissed on that ground.
lordship very well may, but may I just address what I'm addressing? I am challenging the action of the authorities in affirming a fact that there is illegal encroachment, at the same time, not recalculating the revenue.
Have you asked them to recalculate?
This
No,
is-
have you asked them? Or is it easier that you get a direction from this court and then they
Not
do
done
it?
that way.
Then
The earlier
Yeah.
notice was issued on.
after this particular communication, have you asked them that look here, that you have seen all these things now, Kali, take note of this and don't impose upon me the entire amount?
Prior to this,
Where?
10/1/23, another demand notice was issued and the order was at page 120. Prior to this, we're following up the issues, my lord. 120.
Yes.
Operative part 121.
Hmm.
Paragraph 3 onwards would be available.
It is if the relevant
specific-
factors are taken in the aforesaid demand notice would not be issued for a better appreciation of the case. Mr. Bondi, Mr. Swain, leave the matter on initial more particularly and these factors management. Yes, where is the interim order?
It's not, they say state council may obtain instructions more particularly those factors mentioned in paragraph 14. Paragraph 14, we have quoted in page 23, what we have stated therein. Now they affirm this thing, my lord. After
Mr. Bonik,
affirmation.
why have you not approached the authorities after this? And directly approached this court? You know business of that. Ask them,
This authorities,
bring something to show that, look here, that this is the amount I need to pay. You don't have that instruction
my
also.
lord, we,
How much loss has occurred to you? You don't have that instruction also.
occurrence of loss would be a financial calculation to the extent I'm allowed to operate. They understand this thing, but they are insisting on payment on the full. We are seeking for direction, let them come up with that. They would not disown their own findings, my lord. Let them revisit the order. After notice, let them revisit the order.
No problem, let them revisit the
Is it-
order, but I'm not staying
No,
or
no, I'm
doing
not-
anything.
But there is already an order by this court. Your lordship takes up this thing. Page 54. There's already an order. Initially, we said that if they do not revisit long back, there will be a risk sale under 8E of the fishery rules.
Hmm.
Unless an order was passed on page 84, my lord.
Hmm.
Or not 84. This is page 54. Stand corrected.
No coercive measures shall be initiated on the winner till the next date.
And I was giving this, the background of the case, my lord, at page 55.
Hmm.
Why we came at the first stage. The petitioner society was settled with so-and-so fishery.
This order has resulted in you not paying 50 lakhs now.
My only submission,
We clearly clarified that this order shall not be a bar.
we are not on that at all.
Then don't show me that.
But let them revisit the
What?
order.
First of all, why haven't they, the order which has been passed has been correctly passed. Now this is the amount they are asking you to pay. When?
Without allowing us to operate the fishery, my lord.
Where are you saying that you have not been allowed to operate except in a writ petition? Where have you said?
These are communications from
No,
May
there's
I- may I
nothing
point
out
out,
there.
you know,
Don't make all these
page
things.
40, page 40. Page 40.
No, no, no. Nothing
The
doing.
documents are there, my lord.
This is not the case for.
I'm not praying for a stay. Let them a direction for revisit and recalculate. We can come again.
Absolutely no. You get your instructions. Yes. Who is paying for fishery?
I appear.
Then what do you have to say?
In fact, Lordship has rightly held, this is an order which has made the calculation and
One
he's
fishery is being settled.
settled.
It means you have to have a minimum 15 writ petitions. Otherwise, this settling of fishery is nothing. Like some people, when I was doing my civil law, somebody say that in Kachar, one of the basic reason that to show that a person is of a particular level in the society, he has to have minimum two suits for specific performance.
Two
Suits for specific performance. The same applies to fisheries also. The fisheries, one fishery is settled means 15 writ petitions. Then only that matter will come to an end, isn't it?
I leave it to your lordship. But the affirmation is there by the record. We may
Yes.
approach them. That's a different issue,
Yes,
but only so.
Lordship have rightly held, because if at all he is agreed by this order, he ought to have approached. If at all,
Approach them
Yes.
and then come
we,
before.
we might have
We'll approach
settled it for
them. We'll
50%.
approach. Tomorrow we'll approach. We'll
You
approach.
approach them and then you.
And
that liberty will
I
be
tell
there.
them, because here you see, and I don't know about other courts, when there is a demand, and if you can't show how much you are going to pay,
Yeah.
why should I stay the entire demand?
No, I will
It's
not
not
pay
a
for stay.
small amount, because you see the demand starts. 22 lakhs, you come, this court passes an order, no coercive measures. Then 39 lakhs, again you come, then the
Possession.
court says, okay, look into this. Then again, now it's a 50 lakhs, now again, do you want that some order has to be passed to the
In between
effect?
they admit, may not. That admission is by the.
Admission, maybe there, is it, the entire Dihing fishery has been given, only west part has been taken, that is it.
21 odd kilometers gone, may not. The main part with.
What is the total area of the square, the fishery? I'm asking you, you are the petitioner, you may not know.
Around 48 odd. 48 odd, but
So
fishing is.
48 all,
fishing is-
you only say that it is only in the place where you have been disturbed.
This is a reason, there's a reason. Fishes do not swim all around the riverside, my lord. There are gullies, which are called. The points where they breed and the fishing is done. It's in the junction of the Dihing and the Brahmaputra river, my lord. This is a thing factually, and has been approached. I'll give everything and approach. That liberty be granted, lordship, my lord, will be approached. Because their admission is there now safer for us.
The learned counsel appearing on behalf of the petitioner submits that taking into account the communication issued by the SI. What is this? SIP? What is this?
That's the way it was being brought.
What is
The
SIP?
next page, my lord.
What is SIP?
It will be sub-inspector, something, my lord.
That is also taking into account the documents enclosed as annexure T,
And you,
E and annexure U.
You.
The petitioner, instead of agitating the disputes pertaining to the challenge made, but instead of agitating the dispute as regards the amount to be paid by the petitioner in dispute in respect to the communication, in respect to the demand made on 17th of July 2023, would like to submit appropriate representation before the which
same authority. Additional deputy
Additional
commissioner
Deputy
R.
Commissioner R.
Revenue.
before the deputy commissioner R.
Deputy commissioner.
Revenue.
Very good.
What is R?
Revenue.
Deputy commissioner. There is no deputy commissioner R.
No, additional deputy commissioner revenue branch.
The additional deputy commissioner revenue branch, by bringing into the attention of the said authority the difficulties so faced by the petitioner and the difficulties so faced by the petitioner in operating the fishery in question. Taking into account the above, the learned counsel therefore submits that he would not like to press the instant writ petition. However, submit full stop. The learned counsel further submits that in the circumstance, the respondent, the additional deputy commissioner, revenue, Dibrugarh, does not act prejudicially in the interest of the petitioner. By not taking into account the representation so submitted, he may be permitted to approach this court. First, taking into account the above submission, the instant petition stands closed on withdrawal. However, liberty as sought for is granted. So from 15, one is gone, 14. This is going to have another 7, 8 more.
Production is item number 3.
Yes, eviction.
Eviction, Your Lordship,
Eviction from where?
from the government land, Your Lordship.
Then what is this? What
Lordship,
is to
one
do?
aspect is there, Your Lordship, will kindly see, Your Lordship, my case is this, Your Lordship. That suddenly I have been long possessing that plot of land, Your Lordship, with 3 persons, Your Lordship.
Hmm?
With three petitioners in numbers, Your Lordship. They have, Your Lordship, will kindly come to page 25, Your Lordship, that is the eviction notice, Your Lordship, issued by the circle officer. Our case is that out of there, under number of people residing in that particular place, Your Lordship, they have, Your Lordship, circle officer for certain regions, Your Lordship, has targeted only 3 of us, Your Lordship. That's one point, Your Lordship. And secondly, Your Lordship, we have been there for quite a strong period of time, Your Lordship. They have not said why this is required to them, Your Lordship. That is-
Mr. Bhattakur,
Lordship,
can I give a honest suggestion to you? Not here. I think you are a lawyer who can challenge section rule 18.
Lordship.
Because what has happened, I'm telling you. You must have seen all the judgments prior to 1997. Prior to 1997, it was only, rule 18 was only applicable to, in respect of a very, it is only in respect to what you call roadside, land reserved for roadside, then grazing grounds, where settlement was not possible. It was impossible. You can't grant a settlement there. And therefore it was done. Now what has happened? After that judgment, what is that judgment? There is a Supreme Court judgment now. Radha Kishore. Radha Kanu. They have amended this. And thereby bringing in wasteland has been brought in. Now, if wasteland has been brought in, how this court exercise, unless there is a challenge to the constitutional validity of that, because on one hand, they are going to give settlement of that land. And if you can give a settlement, how can you bring that aspect of the matter? And you see, if you see the settlement orders or the regulation, you are to give settlement not only under the regulation, even under the Assam Fixation of Land Ceiling Act, first to those persons who are in occupation. Occupations means where? Occupation in respect of government land. If that be so, how do you take care of a rule 18? Won't there be any violation of Article 14? Not only that. The words which is being used in rule 18 can also, the deputy commissioner can also, or not only a deputy commissioner, if you see 1(3) of the settlement rules, any person, even the subdivisional officer or the circle officer can interfere at the behest of anybody and throw you out. Because you have to have the ownership rights. Meaning thereby that any person who does not have any right as regards this over the land can be thrown out. So unless you challenge rule 18, which has not been done, how do you expect this court to interfere here?
I understand your what has come from your.
I think this is a case you go and challenge it before the division bench. Once you, I think this is a fit case for challenging rule 18. Otherwise, you are having a problem everywhere. You don't have a case. You can't, unless rule 18 says that they can throw, because this may have a serious consequences. It may, even at the behest of a private person may say that this person doesn't have the ownership. And if it is government land, when you are having a particular land grabbing act, why you are not initiating that? Which gives a mode by which there can be a decision or an opportunity of hearing. Because Radha Kanon is, though is a judgment, but did not take into account the various aspects of the matter, just for example, the natural justice aspect, which comes from Maneka Gandhi and everything, that you have to give a hearing, which are 5 judges bench. Something in the, but I can't, with this you can't help it.
Your lordship, my prayer would be, your lordship, therefore, your lordship, that I have already filed a representation before the deputy commissioner. And saying that this action he has initiated on his own and targeted only few of us, your lordship, then that is why it's not proper, your lordship. And therefore, your lordship, my prayer will be to direction to the deputy commissioner to look into it and dispose of my representations, your lordship. I have already submitted, your lordship, with that limited. And your lordship will kindly see, your lordship, 15 days time, your lordship, all along we are there. If 15 days time is given to us to get the land,
Mr. Bhattacharya, this deputy commissioner is so kind enough, or the circle officer is very kind enough to give you 15 days.
lordship, that is there.
Rule 18 does not concept, the concept of giving 15
Yes,
days is
I
not
understand
foreign.
that.
They can throw you out immediately. No notice is required.
At least that representation may be disposed of by the deputy commissioner. That I would otherwise would have prayed this only, your lordship. I know my limitation, your lordship. In a case of this nature.
Mr. We'll take it up tomorrow.
Lordship.
You get hold of one order, I'm giving it to you. The reference also, 10/2/2023,
Lordship.
passed in PIL 6. That is a division bench order passed by Justice Buzar Barua and Justice Robin Fukon in PIL number 6. This will give you help. List the matter tomorrow at 10:30.
Deeply obliged.
But you need to challenge this.
No.
At different places. I completed my work successfully over the decades at different places. My lord, an NIT was issued, which is at your page 26.
Affidavits, everything is complete.
Everything is complete, affidavit has been given.
They sought time on last occasion to file reply,
That's all, I don't think it is not advisable now. I'll reply is not necessary. Is that good? 26 is the, my lord. It was a contract for two years, 17/4/20. 20 page 27, that serial number 8 is the contract in question. Man. The estimated value of the contract, 4 crores. Security, earnest money, these are given, security deposits at the rate of 15% VOC, value of contract and all. So I, observing formalities, I commenced work, and my lord, the work was finished in last April. So during the pendency of the tenure, I had to approach this court because of certain communications by the FCI insisting upon additional security on me, which your lordship will find at page 46 first. It was an internal communication. It was not given to me between the divisional manager, deputy general manager and divisional manager. That FCI has, there have been instances where VOC, value of contract in some handling or transportation works exceeded amount prescribed in the appointment order. As observed, it has been done due to various exigencies or inclusion of schemes such as PMGYK and subsequent extension thereof work volume may anticipate, my lord, it is anticipated, increase beyond the amount mentioned in the appointment order, result in excess work to be done beyond VOC, value of contract. As such, extra valuation of the value of contract is difficult. Therefore, in order to safeguard, in case the value of work exceeds, as in when it exceeds, my lord, These division managers are directed to obtain proportional security deposit for the amount exceeding POC. So this was a communique of my just 3 months prior to the expiry of my contract. Then my lord, next page, the notice was given to me. Notice was given to me. Page 47. Whereas you were appointed transport contractor period of 2 years dated so and so, and advisory, which I read already. has
Now the
received-
period is over.
period is over. Now, my lord, I finished. At that point of time, my lord, I approached this court that, well, there are certain works where suppose the value of the contract is 5 crores over a decade. I was allotted only with 2 crores of what works. There, my lord, they don't decrease the security deposits. And now anticipating that they are, my lord, first order, this court protected me. Lords may have a look at the first order passed by this.
No, Mr. Barbara, what remains now?
Now, my lord. Lords
If
may
the
have-
contract is over?
No, my lord, there are the other limb that remains. Other limb of the prayer and the cause title and the prayer and grievance, my lord. Lords may come to the last page, the chart of the, my lord.
Now, what limbs
Yes.
remain?
This is my lord.
You are asking for quashing of
No,
advisory 5-4 that has gone.
that is all.
Input notice has gone and declare the action of not refunding the security deposit made by petitioner as Annexure 5 even after satisfaction. So you have not been refunded the security deposit.
So far as this particular work,
Ah.
so far as this particular work, we have been given
Ah.
and the bills were paid. So
Hmm.
far as this particular work, of
Hmm.
course, some amount is remaining, but the main grievance, another main grievance is at Annexure 11, my lord chart.
Hmm.
The non-refund of security deposits in respect of number of works, my lord, since 2015. Lords may have a look at the chart. Last page of the my lord read petition. That was the second limb of grievance. What was under challenge, non-payment, which is there, my lord.
So you are entitled to this
Now,
83
my lord,
lakhs.
have a look. These, all these contexts, there are 30 in numbers.
Hmm.
It is a my lord modus operandi, my lord, I say highly expectative, I will submit, my lord.
Hmm.
From 19, no complaint, I finished the works. The bills were paid, some works ad hoc, 3 months, some 6 months, some 1 year. There were 30, and the CD, my lord, duration of the contract. And CD, my lord, contract year 2015, it starts from 2015 ending on 6 years. Now unrefunded security deposit, last column, my lord, it comes to around, my lord,
83 lakhs.
83 lakhs. These have not been refunded to me for no rhyme and reason. Actually, my lord, clandestine, my lord, modus operandi.
Yes, why haven't you refunded?
And
What?
against that, almost out of 30, my lord, 20 security deposits are already released. My lord, can they have a look at it?
Why not the remaining 10? There is an order. my
There
lord.
are some,
Lakshmi, look at the order, clear order by this court.
and my lord, 2 under process and 2 cases, he has not submitted NDC. And against 3, my lord, there are some recoverable amount is there.
My order, no, it's a second order.
This is,
Out of 30,
28.
you have released 1, 2,
20, my
three,
lord, 20.
20 has been released.
Yes, my lord.
Now NDC not submitted.
Yes.
What
my
is
lord.
NDC?
No demand certificate, my lord.
No demand certificate has not been submitted. And the others, NDC cannot be
In
processed.
2 cases,
after
NDC
it
not
is
submitted.
As the total value of the work exceeded DOP so and so.
That is under,
Petition pending, value filed by the contractor in connection of recovery on account of AR matter is subjudice. Okay, Mr. Counsel, why have you filed this on record?
no, my lord.
You file it on record.
No,
Bring.
they have, my lord. In fact, the
But
affidavit.
this aspect I have not been brought.
So
Have you
my-
brought on record this thing?
No, my lord.
Nothing.
So my instruction is from 2015, my lord. These all this
Now, Mr.
security.
Barbara, let him bring on record this so that you can have a say out there if you are asking for return of this, because there are certain matters, just for example, item number 2. You are asking that money, but there is a matter pending before the High Court, which is pending.
My lord, assuming that is minus, even then, my lord, as on date, they have not released around 26 lakhs of rupees to me till yesterday. And one more thing, what about the interest? From 2015, they are keeping my bank guarantees and security deposit. They are not keeping it in an Almira. They are keeping it in their bank account. So am I not entitled to?
Mr. Barbara, bank guarantee in the Almira, doesn't
They keep it in their account, my lord. FCI. All this security deposits money.
Okay,
So I am entitled to interest also. That is also my.
we
pay.
will see. Mr. S. Chakraborty appearing on behalf of the FCI.
SK Chakraborty.
Huh?
SK Chakraborty.
SK Chakraborty appearing on behalf of the FCI has drawn the attention of this court to the fact that has drawn the attention of this court to in reply to the annexure 11 of the writ petition, stating inter alia that out of the 30, 20 secure deposits have already been released. However, 10 have not been released on account of pendency of some writ petitions.
No, not 10, my lord. Only one. In the affidavit, they said only one. No, paragraph 5 of the affidavit.
No. How many? No, there are many not
Yes.
released.
The two NDCs are another process.
And 10 have not yet been released
Yes,
on account of pendency of the writ petitions. Some certain writ proceedings, as well as for non-furnishing of the no due certificate.
No
as well-
demand certificate.
no demand certificate by the petitioner, as well as also on account of certain amount to be recovered
Yes.
from the petitioner. Full stop. This aspect of the matter has been drawn to the attention of this court has been made on the basis of a status report being submitted by the Assistant General Manager Contracts of the Food Corporation of India. Full stop. This court is of the opinion that the said be brought on record by way of an affidavit so that the petitioner can also rebut to such allegations. List the matter again on when?
After 3 weeks.
Huh?
After 3 weeks.
After 3 weeks, we will have it on, let the matter be again listed on 25th of August 2023. The affidavit be filed by 21st of August 2023.
Only wrote in the report that my instruction is that even today, around 16 lakhs rupees are unpaid.
No, he himself says also that is there.
He has not paid.
No, Mr. Barbara, he categorically says there in that document.
No, I am going by their affidavit. Their affidavit, they mention that in a writ petition pending 5486 of 22 filed by the before High Court, except the aforesaid amount, all other payable dues would be released. They were mentioning in their affidavit only about one pending case. And in fact, there is only one pending case where 18 lakhs.
Let them put it on
So
affidavit.
my submissions may be recorded, my lord, yet dues are not paid.
You have a right of reply, Mr. Barbara, you will get it. 20. Yes.
Yes, Lordship, in that case, I am challenging the proceedings which is pending before the election tribunal. Is the annexure 1, page 16 of my repetition.
What?
Challenging the proceedings, Lordship.
Of what?
Challenging the proceedings of an proceedings whereby paying for set aside the election of ward number 7 of Moriani Municipal Board of the election of municipal election 2022.
The records not called for.
The record was not called for, Lordship. in that case.
Okay. What has happened? You have challenged it. Their election has been set aside.
No, Lordship, they are praying for us challenging the set aside the election proceedings. And there is a provision, it should be filed within the period of the 21 days. And this application has been preferred after expiry of the time frame. And since this act is in special.
This is under the Panchayat?
Assam Municipal Act, Lordship.
Okay, Assam Municipal Act.
Yes,
So they have challenged that your election.
my election.
And then
Lordship, that.
you challenged it before the district judge.
Yes, they challenge before the district judge. We are challenging that particular proceeding which is pending before the district judge. Because he entered in this petition which is filed after expiry of the time frame.
Then what happened? What did the district judge do?
District judge has issued the notice to me without taking into account of that there is a delay.
So why don't you file an application out there?
Lordship,
I think the CPC applies out there.
yes, Lordship.
Then why you're not filing it?
Even Lordship, they have, he has permitted the private.
Mr.
respondent,
Counsel,
Lordship,
go and file out the order 7 rule 11 and say that this is barred. This is how it is being done in all election matters out there, including here also. If there is a delay, just for example, you are to present as per the representation of People's Act, you have to present as by in 83 within a particular period. Now, if you don't do it, you are to file an application under Order 7 for rejection of the plaint or the proceedings. I think the CPC applies. What are you doing this? And how this court would do all these things? These are all judicial orders passed by this court. You file under 227. But this is not a proceedings where you are taking it. Go there, appear and file your application. I think the CPC applies there. Isn't it?
And in fact, Lordship,
This will, I think the principles of the Representation of People's Act apply. So there the CPCs apply.
Yes.
So therefore you go and file there.
Lordship may given some time frame to dispose, consider my application.
Have you filed it? Then the learned counsel appearing on behalf of the petitioner submits that instead of pursuing the remedy out here, he would like to file appropriate application before the district judge Jorhat
Municipal election.
in before the district judge Jorhat in Miss J case number 20/2022 pending before the said authority for rejection of the said application on the ground of delay in filing the election petition. So taking into account the above, the instant petition stands closed. However, liberty is given to the petitioner to approach the learned district judge in the said proceedings.
last month.
21.
Interim order, if any, stands vacant. Yes.
Lordship had sought for instructions in this matter.
As to whether the competent authority in pursuance to the report submitted by the surrender have passed an additional award. Yes. What have you done?
In fact, the reassessment has been done and has been compared with the 3Z. And finally, it has been placed over to the National Highway and Infrastructure Development. But till now, they haven't given any approval to that for which the compensation amount.
That was there, the same aspect what you are saying today
Yes.
was there on that date also.
It is in the.
I remember that this was the same thing. Your submission, your or Mr. Gustami, whoever, yes, your submission.
No, Goswami.
No, you were there on the last occasion. Your name has been clearly appearing. It was specifically submitted on that date that the authority have placed it before the NHAI for the purpose of taking their approval as to whether to pass this additional award or not. Then I put a specific question to either of you who are appearing, stating that is the authority, the competent authority, going to fix the award on the basis of the pleasure of the NHAI. That is what I put. And that is why I asked you to obtain the instruction. You have not obtained the instruction.
Yes.
Why haven't you passed the additional award? You have to pass your additional award. Whether he doesn't pay, then he has his recourse to take. You have to pass your additional award. Mr. S. Borua appearing on behalf of the respondent, appearing on behalf of the state of Assam. That is the competent authority shall apprise this court on the next date as to whether the additional award has already been passed in the case as regards the grievances of the petitioner, as regards the entitlement of the petitioner. List the matter again on 14th of August, 2023. Get a pass the additional award, then we'll look into it. You have to pass an award. Forget about what the NHAI did.
For my instruction, no additional award has been passed.
Let him pass. Why?
No, that we have stated.
Why the additional award cannot be passed?
I have an affidavit also. As per the in their read petition, they have mentioned the circle officer has estimated the amount. Last page notice that the petitioner is about to get the rupees 26,78,084. We have already deposited 29 lakh.
No, that is for some Zirat amount.
No, actually, the
No,
thing
regarding
is,
all amount.
they have calculated it to be the valuation, they have calculated less. And this 26 lakh or whatever they are saying, whatever they have paid, that is after the formula of schedule 1. So what we are saying, the valuation itself should be 26 lakh and so much. And after that, of course, the formula of schedule 1 will apply and then amount will be even higher.
But as per the,
They have given you only 26 lakhs.
No, they have paid us about 32 lakhs.
Okay, fantastic.
including,
But 32 lakhs, does it include the value of the land,
Value of the land, yes.
100% solution?
Yes.
and
Then
building.
the interest for this particular portion from the date of the notification under section 11 to the, but here notification does not come. That is not there, but 100% solution is there.
So far as land, it is all right.
Yeah.
And
Now,
they-
only issue is that they have taken, they have acquired in two phases. In the later phase, initial phase, only our veranda was gone of our building. In the later phase, a lot portion of our building is to be demolished. So that valuation, they are not clear.
That is why
Yes.
on the last occasion, when the matter
Yes.
came up before this court, the executive engineer has given a report,
Yes.
isn't it?
Yes, yes.
And on the basis of that, they were to pass an additional award, but they were inquiring with the NHAI.
Yeah.
That what can be done?
Yeah.
I put a question as to, are they going to ask the NHAI for this?
Correct.
That is it. You obtain your instruction.
23,
Yes.
Matter particular non-payment of medical reimbursement bill matter. There were husband matter for the matter. Yet undergo treatment matter.
Medical reimbursement bill.
Matter.
Why? How much?
It is admissible amount comes to matter 4,98,333. Page 18. 18.
Yes.
Total amount spent was matter 5,24,520.
Then why you asking something more?
No, my lord, total amount was 5 lakhs, my lord, but
Where is it admitted?
Yes, my lord.
Where?
My lord, that is a admissible amount to rupees 4,98,330. Last time.
So they have admitted only 4,98,330.
Well, that amount maybe.
Yes, Mr. Bo.
After some time, the woman is appearing, he is holding the brief. After some time, he has got some instruction.
It has been given. Why you are not making the payment? If he is entitled to.
Lot.
We'll have it on Friday.
Right.
This is the matter again on Friday.
Lovely.
As the learned counsel is in the Upor Nam to Eon Nam Nidi Bodhe kar. As the learned counsel appearing on behalf of the health department is not present.
Lovely.
24,
খালি উপরে একার নাম দিই। Divisional নাম। Yes. Yes. What is this? Shall be passing the order in terms with PG within a week. So you have passed that order.
Lot.
Then what remains? So you have passed the award. Now, after the award, now if he's aggrieved, he can very well approach, challenge it. Isn't it?
Yes.
Now, where's the award, the total, as regards the petitioner, where is that portion of the award? The compensation and all, award list here, then award list, estimated copies, what is this? Mr. N. Goswami appearing on behalf of the district commissioner, Hailakandi, have placed before this court an order dated 24/7/2023 passed by the District Commissioner Hailakandi. However, the said order does not reflect as to whether the same order pertains to the case of the petitioner, taking into account the learned counsel, Mr. Ngusami, is directed therefore to apprise this, bring on record the award list wherein the name of the petitioner is reflected. List the matter again on Monday, Tuesday, Wednesday, 4th. Wednesday is 2nd of August. Second. Hailakandi na. Too far. Second.
55th.
What is this matter? Fishery. Intend the prayer would be considered on a parental justice. It is hereby provided the status quo as regards possession of the petitioner in respect to the land covered by it shall be maintained. Yes. What is this? You are in possession of what land?
Government land.
Lordship may kindly come to place. 36, Lordship.
You have initiated with 18. Rule 18 or what?
36.
What are you challenging, Mr. Counsel?
Lordship, actually land is pata land and land is our possession at least 80 years. Lord. From my great grand
Written to non
Father place.
settlement of land measuring in favor of petitioner covered by.
upon that feasibility report, Lordship.
No, this is as regards a Khotian.
Yes, Lord.
So Khotian means dark number is Khotian number. This is government land.
Lordship.
If you are asking for settlement, that means it has to be government land.
No, Lord.
But no. If you are asking for settlement of that land, it has to be government land. Or are you doing under section in the? Then why are you not invoking under the 71 Act? So is this the writ court? It has become the authority under section 25. Oh,
Do not know. May kindly add on property. Add on. Lord.
fantastic. At the request of the council, matter stands adjourned for 4 weeks.
Yep, yep.
26 to 30.
May relating to contract payment, my Lord. And my Lord.
Non-payment of bills.
Yes, Lord. What are the?
We are the executing authority, Lordship. TC is to pay, Lord.
My Lord, revenue and
Yes,
disaster management is the
My lord,
funding authority is the
we're
revenue.
waiting for a justification report from the deputy commissioner, my lord. We have received it. Now it is under process to release the fund, my lord. Give me 1 month time, my lord. to Release the fund, my lord.
I give you 2 months.
Okay.
খালি ওপৰখিনি লিখিলে এই এখনত মই ডিক্টেশ্যন দি দিছো এনে ওপৰখিনি লিখি ল'ব আৰু তলখিনি মই কৈ দিছো Mrs. P.R. Mohanto, appearing on behalf of the Revenue Department,
Yes.
had submitted that the justification report have already been received from the Deputy Commissioner, wherein the entitlement of petitioner have been admitted. Admitted. And as such, the Revenue Department would be releasing or disbursing the said amount to the Deputy Commissioner or to the them,
Deputy Commissioner.
to the Deputy Commissioner. Which Deputy Commissioner?
DC Korimganj.
Korimganj.
Deputy Commissioner Karimganj, who in turn shall disburse the amount to the petitioner. Taking into account the admitted stand of the petitioners, of the respondent authorities, where there is no denial to the entitlement of the petitioner, and that the process of verification is also complete. This court therefore directs the Revenue the Commissioner and Secretary, Government of Revenue, Government Department of Revenue, Commissioner and Secretary directs the Principal Secretary to the Government of Assam Revenue and Disaster Management to release the funds to the Deputy Commissioner Karimganj within a period of 45 days from the date a certified copy of the instant order is served upon the said authority, upon the Principal Secretary to the Government of Assam Revenue and Disaster Management Department. The Deputy Commissioner Karimganj, immediately upon receipt of the said amount, shall within 15 days from the date of receipt of the funds from the Revenue and Disaster Management Department, shall release the said amount to the petitioner. A copy of the a certified copy of the instant order be also furnished to the Deputy Commissioner Karimganj for effective compliance. With the above, the petition stands, with the above observations and directions, the petition stands disposed. আগৰখিনি ওপৰখিনি লিখি দিব, তলতখিনি মই এইখিনি কৈ দিম।
All five are same.
It is why all 5 matters, 5 or 6,
26.
6179, 6222. Oh, yes. 6482, 6484, and 6229. All are same.
All are same.
খালি এইখিনি ভৰাই দিব, নাম লয়। You give your name, you are water resource.
Yes, sir.
He is Deputy Commissioner.
31.
Yes, big matter. Tell me, what is the matter about?
This is about, my lord, we are the shareholder of a society whereby my learned friend's client, there was a board, which board, my lord, automatically it get dissolved. Because there has been AGM every after annual AGM has to be there. Now, in this case, my lord, they were elected on 6th of February 2020. So, but there was a COVID at that relevant time. So they could not hold the AGM. Now, by virtue of 120A of the Assam Cooperative Society Act, if there is a pandemic, then automatically it gets extended. So government has number of cooperative society applied, and accordingly it was extended. The last period of extension was 28th of February 2022. Before that, they have to hold an AGM. What has been done in this case? 17th of March 2022, the first AGM was called. Thereafter, my lord, on the AGM was called, there was no quorum. Then, my lord, 1 week time, on 24th of February 2022, second AGM was called, there was no quorum. On 24th of February, 24th of March 2022, my lord, third AGM was called on 31st of March 2022. What they have done, 28/3/2022 was the last date. Only to save that date, on 25th, they have issued a notice to the shareholders that they are holding an AGM on 28th of February, 28th of March 2022. And accordingly, my lord, 28th of March 2020, AGM was held. And that resolution was sent to the Assistant Registrar of Cooperative Society on 4th of April 2022, and it was approved. So we wrote a notice to the Cooperative Society, how can they hold an AGM on 28th of February 2020, 28th of March 2022, because they called an AGM on 31st of March 2022. 28th was the last date. Automatically it gets dissolved. Now, my lord, we moved in High Court. Before this Honorable Court, we moved a writ petition. But there is a point of maintainability. The writ petition is not maintainable. There are other forums. So accordingly, we filed an application under 111 before the Assam Cooperative Society Act. So that was pending before the Registrar of Cooperative Society. In the meantime, there were a number of litigations before this Honorable Court. So now what has happened in the meantime,
the judgment came, raised of court which was in our favor. And they said that automatically it get dissolved. But there was a rider which was given to them. That even then, if you want an exemption, for the second exemption, you can move before the court, before the government, second exemption. But the order passed by Register of Cooperative Society was that it get dissolved. Because it becomes a nullity. On 28th of March 2022 was the last day. How can you hold an AGM? 28th was last 30. They have extended 31st of March 2022. So, my lord, which it went against them. They did not prefer any appeal. They went to the government also. Government also did not interfere it because when they challenged before the government, that rider which was given to them on the second part, they went to government, they did not get any decision from the government. They came and filed a writ petition before this honorable court. And at that time, my lord, on instruction was received by government has given an instruction to the court saying that we are not entertaining the second exemption on the ground because there was no COVID at that relevant time. So this was the case. And in the meantime, what has happened? One-man committee was formed, and accordingly it was going on, one-man committee. Now, my lord, they have put to challenge the one-man committee. It was pending before the court. Now they came up before this honorable court, my lord, and on the ground they have stated one writ petition which was moved before this honorable court, and they said how a second exemption was not granted because there are other cooperative societies where second exemption was also granted. They said these are discrimination. There is one judgment passed by this honorable court which was dealt by your lordship, and your lordship has said that that was a different situation. We have annexed that. Then court, because they have come up before the court, before the resolution of the court, and the government said that we can't allow you because there was restriction of number of people because 2022, that was February. So the situation in that case and where your lordship allowed was a different context. Now what has happened when they moved before this court, taking say on the ground that second exemption was not granted. This is discrimination because there are other cooperative society where second exemption was granted. Court said get an instruction from the government. We want to know which are the cooperative society where second exemption was granted. Now, when they took the instruction, now they issued an order saying in pursuance to the High Court's order, we are granting second exemption. So we have put to challenge the second exemption also. That part of the government before this court.
Who are you?
I am the shareholder. Shareholder of the
Why are you
society.
challenging?
We are challenging because there has to be a press election under 41.
So let them hold the press
They
election.
are not holding it. They are not holding it.
Well, why are you not holding?
I appear for the court respond number 8, Milord.
Why are you not holding the election? You have got a second exemption. then why
Elections have been held. AGMs have been held.
Then
That is not under challenge. That is not under challenge.
it's not on the challenge.
That's not under challenge precisely.
No, subsequent
May-
AGM, we have
if my
we
senior-
challenge the
once
subsequent AGM.
Once my senior colleague would finish addressing, I'll respond, Milord.
No, I'm only asking you, have you hold the
Yes. We have-
AGM has been held pursuant to the second
Yes,
extension?
yes.
We
It's all-
challenge that.
Huh?
We challenge that. We
That also
challenge
you
that.
have challenged.
No, we have challenged.
Oh, that it
We said, how can you hold it? Because once by virtue that register has already passed an order that it get dissolved, there is no question of holding a second AGM because it get dissolved.
Well, there are
Now
other
we
connected
challenge.
cases.
Well, we challenge the second extension which also granted because once the
You have
government,
challenged the second.
yes,
extension.
the government said, I will show that order. Government said we can't give you extension because there is no COVID.
But the government later on granted the extension.
That's why I'm saying.
But have you challenged that?
Yeah, we challenge. We
Why?
challenge all this.
No, understood. Why you are challenging it?
We are-
You
we
should
are-
go for an election.
No, what we are saying. My lord, their term was for a period of 5 years, 6 to 2020. Now from there, every year an AGM has to be held. They have to hold an AGM. Now in this case,
In 6 months of the ending of the financial.
yes,
Now, they could not held it.
Hmm.
They could not held it. My lord, first exemption was granted because at that time fulfilling COVID was there. Now, when the first exemption was granted, 28th of March 2022 was the
But Mr.
last.
Das, I understand everything, but
Yes.
why are you challenging all these things? If you are a shareholder, you should have participated in the elections if it was held.
No, election is not the ground here. We are saying, we are challenging that this board that automatically get dissolved, there has to be new election because they could not hold the
Unless
AGM.
who is going to hold election? It will be done under 41-6.
No, that's why we are
Why
saying.
do you need a one-man committee?
we don't
Why do you
want.
need Mr.
No,
Talal?
no.
In absence of quorum on the 34,
No, we
41,
don't
6 is not
want.
even attracted, my lord.
No, we don't want.
Malad, may I intervene? Malad, there are three connected writ petitions filed by the same petitioner. Those are connected matters. Malad, those are not listed. All the four matters, Malad, should be taken up together. There's a connected issues. My learned senior has said it is a challenge. Those, Malad, the writ petitions are not listed today. I have the numbers. Lordship may, it will take some time, so Lordship may say, Malad, some other day. Then your Lordship may, yes, I'll give the numbers. Malad. WPC 5741 of the 22.
Appearing on behalf of the Operation Department.
My lord.
That apart from the instant repetition, there are another three
Three
repetitions
writ petitions, my lord.
which are similar in nature
By
and
same,
connected to the same cooperative
Yes.
society.
and by the same petitioner as well.
Connected to the same cooperative.
Cooperative society and by the same.
And as such, for the purpose of a proper education, all the repetitions be disposed or be taken up for consideration together. He submits that the state repetitions are so and so, so and so, so and so. The matter will be listed again on when you are a BT council. Tell me.
Important. Tuesday.
Tuesday is too early. Let it be on 8th of August.
8th of.
Is the matter again on 8th of August? On which date an attempt shall be made to dispose of the state.
My
Is
lord,
the
this-
matter on 8th of along with the repetition number so and so, so and so, so, on
I'll
which
give the
date an attempt shall be made to dispose of.
Obliged.
Actually,
Very
this is the main repetition. Maybe that may come up, but that's the.
Let all the way, because tomorrow they may say underground that we said all these things, the learned single judge.
In fact, the elections were held under orders of the honorable single judge, which is not on the channels, my lord.
Not
Yes,
only-
yes. Obliged.
Yeah.
Please don't say that these are elections. These are not elections.
No,
All you are saying
under
is an election.
under the act,
Don't
it's
get
an
dissolved, my lord.
AGM
We are
election.
not
We'll
a-
argue on the law, my lord.
Don't say.
One
this.
second, we'll argue on the law. I'll address your lordship in every point.
Yeah, next time.
Number 32.
Not in this case, I need 2 weeks time. Lord.
Hmm?
I need 2 weeks time.
Mr. N. Gustami appearing on behalf of the respondent. Seek for an accommodation of 3 weeks for the purpose of filing the affidavit in opposition. List the matter again on 28th of August 2023. The affidavit be filed by 23rd of August.
33.
Yes,
Lordship, the matter may be adjourned as Mr. Simantan Yogi is not available today.
this payment of amount,
Partial payment.
non-payment.
Non-payment.
Yes, verify and pay. Madam, verify and pay. Verify as to whether he's entitled or not, and then make payments. And dispose of, huh?
Obliged.
Within 6 months from the date a certified copy is served. Verify as to whether the petitioner is entitled to and make payment thereafter. Period is 6 months from the date the certified copy is. Yes.
Thank you.
Ah,
My lord, in this case, my lord, the
seek
petitioner
for an accommodation, the arguing counsel is indisposed for personal reasons. Tell me.
petitioner is a contractor, my lord. He executed the work, my lord.
when final payment was made, an amount of rupees 30 lakh was withheld as forest royalty, my lord.
Ah.
My lord, petitioner paid the forest royalty in Mizoram government, my lord. Then when he submitted the forest clearance.
The learned counsel appearing on behalf of
Mr. D. Gokul.
D. Gogoi.
D. Gokul.
D. Gogoi. Okay. Where is your affidavit?
Lordship, sometime may be granted, we'll file it.
Okay. The counsel appearing on behalf of the Forest Department seeks for an accommodation for filing the affidavit in the matter. Taking into account the issue involved, this court grants the Forest Department to file grants 3 weeks time to the Forest Department to file the affidavit. List the matter on 30th of 3/08/2023. The affidavit be filed by 23rd of August 2023. It is further observed that if there is further delay, this court shall proceed with the disposal of the petition on the basis of the materials on it.
Oblige your
55.
Yes.
Yes, last of last instruction was put forward.
Hmm.
I have provided this.
You have not taken any money.
No, my lord.
Why?
My lord.
Why you are not taking? You can always take money under protest. Isn't it?
Yes, my lord.
Always, whatever money you get, you take it under
No, my
protest.
lord, not money was not offered, my lord.
He says 40 lakhs
No,
was
no.
offered.
No, that was another land, my lord. My case is not that, my lord. Already appeared 1 week some 7 lakhs of land, and that thought this award was compensated, and that I have been received.
You have received the 40 lakhs.
That, my lord.
Okay.
That is not my grievance. Another grievance, excess land 4 weeks.
Refuse to
something is-
accept the claim claiming compensation. But what is this instruction? This instruction is wrong
Yes, my
then.
lord, that is our case. My lord.
He says that he has already, you have already received 40 lakhs.
Yes, my lord.
Then what is this
I am
instruction?
not, my lord, opposing that.
There is another amount of
Yes, my lord.
1 crore 14
11
lakhs.
lakhs.
Have you passed the award?
Not passed.
That
Why?
is-
This is placed before the National Highway Authority. Lordship.
Why? What is this NHI? Yes.
My lord, my lord, for lordship. Yes, the last occasion, lordship was pleased to ask them who are the requiring agency. Now, according to him, because though I have seen, Dasna have seen, my lord, this is seen by this land has been acquired. Ministry of Road and Transport Highways, as per requisition submitted, Executive Engineer, PWD, NH Division, not by NSAI. That is yet another wing. My learned friend,
Of the state government.
no, state government, it is PWD, NH Division, my lord. One is NSA DCL, one is NSA, NH Division.
So you
Now
have
NH
no
Division.
role.
No, I'm
You-
not.
Then why you are not taking into action? Who is PWD?
NH Division.
Yes.
PWD, NH.
Why you are not making the payment?
Possibly, I have to take the instruction. PWD NHA is not a party here. We don't have notice of this case. Respondent number 4 is the NHA, National Highway Authority of India.
No, we don't require all this, the PWD.
The PWD NH, if NH is the requiring authority,
In pursuance to the order dated 19/7/2023, Mr. S. Dutta, appearing on behalf of the, no, who has produced this? You. This, who has produced this document? Oh, yes, Mr. S. Dutta, appearing on behalf of the Revenue and Disaster Management Department, have produced an instructions dated 21/7/2023. From a perusal of the said document, it is apparent that the land has been acquired for the Ministry of Road, Transport and Highways, and as per the requisition submitted by the Executive Engineer PWD Rongia NH Division, Rongia. Full stop. The learned counsel, Mr. C. Borua, appearing on behalf of the respondent number 4, submits that the National Highway Authority of India therefore has no role to play in the instant proceedings. Who is appearing for respondent number 5? Union. None appears on behalf of the Union of India representing the Ministry of Road, Transport and Highways. Oh yes, yes, what do you have to say?
Party shipping road to transport.
They have made party responsible by a shipping and road transport authority. Based on a pipe loss. No,
As per communication, not is
communication. It should be Lordship, Ministry of Road Transport and Highways, Lordship.
No, it is there. So let us remove the shipping from there.
Lordship.
So road transport and highway is there. Then are you the requiring authority?
Lordship, I have to obtain instruction under.
There you have been issued notice all along. Somebody is appearing.
What can I do?
Ki likh rahe tu? Last line tu? No. Full stop. Mr. K. K.C. Gogoi.
K. Gogoi.
Mr. K. Gogoi appears on behalf of the respondent number 5 and submits that he would like to take instructions in the matter. It further appears that the said land has been acquired as per the requisition submitted by the Executive Engineer PWD Rongia NH Division. Rongia. However, the PWD is not a party to the instant proceedings. Taking into account the issue involved, this court finds it appropriate that the PWD is required to be made a party to the instant proceedings. Accordingly, this court impledes the Commissioner and Secretary Government of Assam, PWD Department having his office at
Commissioner Dispur,
Guwahati.
PWD Building and NH. There are two departments.
Which one?
This is NH, PWD Building and NH.
Commissioner and Secretary, PWD Building and NH, as having his office at Dispur, Guwahati, 781006, as the respondent number 6 to the instant proceedings. Mr. D. Nath, the learned counsel, accepts notice on behalf of the newly impleaded respondent number 6. Extra copies of the writ petition be served upon him so that he can take appropriate instruction in the matter.
I also pay for a copy of the.
The petitioner is further directed to file a memo of parties before the registry of this court by 28/7/2023. As regards the impleadment of the respondent number 6, to the instant proceedings. The registry shall make necessary changes to the memo of parties, shall make necessary correction in the records as well as also in the CIS on the basis of the said memo of parties filed by the petitioner. Mr. D. Nath as well as Mr. K. Gogoi shall obtain necessary instructions as to which authority would be making payment as regards the acquisition of the land of the petitioner. List the matter again on 28 August 2023. Mr. Counsel, give a copy to him. The instructions so submitted by Mr. S. Dutta is kept on record and marked with the letter X.
My lord may also directed a registry to lordship in respect to response of 5 lordship. It should be lordship Ministry of Road and Transport shipping other department lordship, then it will.
You are there now.
Lordship, I'll do. No.
36.
Tomorrow the council may also want to put a housing also.
Lordship,
No, nowadays there is a lot of problem in changing this.
lordship.
You see the CIS.
Lordship.
Now, whenever you file, nowadays is all this e-filing is going on. Now, whenever you are filing it, it automatically goes to the NDRG or something. National Judicial Grid Data.
Lordship.
Now, once it goes out there, if you want to make a change out here, there are a lot of formalities.
Lordship.
So that is why that memo of parties has to be filed.
Lordship.
You file it, otherwise it will be a problem.
In the court list, PWD may be shown.
The register, no, then it will be shown. This has to be shown then. Anyways, the registry shall also show the name of Mr. K. Gogoi appearing for the respondent number 5 and Mr. D. Nath appearing on behalf of the respondent number 6. Yes. Yes. What is your matter?
Affidavit is required to be filed by the official respondent.
Yes. Who is this PNRD? Who is to file?
Yes, PNRD, my lord. And Deputy Commissioner is also my lord party.
What are you asking for?
I am asking for my lord clear reflected in page 48, my lord. Kindly. Page 48. This is the report of the executive board.
Who are you?
My lord, we are the locals of the Gornover Gaon Panchayat, my lord, where the market is situated, my lord.
And then?
Market, my lord, is my lord situated over 12 bighas, 8 acres land, my lord. And my lord, what happened, my lord? It has reduced to 3 bighas only now, my lord, due to random occupation, my lord. So, my lord, what happens now, my lord? There is no drainage system, my lord. There is no, my lord, rest house. There is no, my lord, parking zone, nothing,
Okay.
no committee, my lord.
Who appears for this? Mr. Doctor, you are appearing? You are appearing in this matter as Doctor? Oh no, that is the PNRD one.
My lord, I'm appearing on behalf
You are
of.
filing affidavit?
No, my lord. My lord, the main grievance is against Deputy Commissioner.
Yes, Deputy Commissioner.
We'll
What is your
file-
stand?
We'll file up. We'll file up.
You get your instruction, not necessary. Mr. N. Goswami shall obtain instructions in the matter. In respect to the Mr. N. Goswami shall obtain instruction as to why the land allotted to the petitioner,
Not petitioner.
the land allotted to the Gaurinagar market have not yet been demarcated till today, nor handed over to the Ansalik Panchayat. List the matter again on 21st of August 2023.
Sir, 57 supplementary list.
It does. Through admission. Yes. Yes, you got your instructions? What is it? What has happened to the application filed by the petitioner seeking partition?
It is pending.
With reference to, I have the honor to inform you that all records of the mayor Kamaika revenue were submitted to the pending before this. All the revenue. Yes, now, when?
Just 1 month.
My lord. My lord, I am on behalf of MS R. Chaudhary, my lord.
You are on behalf of?
MS R. Chaudhary, my lord. Council of Respondent number 4, my lord. He instructed me about it because of some personal problems. He left the court, my lord. He over telephone
They want to do, let them do the demarcation. You have any objection? I'll issue notice. The deputy commissioner will issue notice. You have any objection? You file objection under the Land Revenue Act.
They have not shown the entire land. That is what I have been instructed.
Mr. Counsel, whether land has been sold or not, they have filed a partition application. Once the partition application has been filed, the deputy commissioner has an authority to look into it and will also invite others. The moment you say that you dispute the title, then the deputy commissioner in terms of regulation 101 has to refer it to the civil court. Isn't it? Then the petitioner herein is aggrieved by the inaction on the part of the respondent authorities, inaction on the part of the Office of the Deputy Commissioner, Kamrup Metro, in not disposing of the partition petition being case number 7/2011-12, which is pending before the said authorities since the year 2012. This court, by an order dated 24/7/2023, directed the learned counsel appearing on behalf of the Deputy Commissioner, Kamrup Metro, to obtain instructions as regards the application filed by the petitioners seeking partition. Mr. N. Gusami, appearing on behalf of the Deputy Commissioner, Kamrup Metro, had produced an instruction issued by the additional Deputy Commissioner, Kamrup Metro, wherein it has been mentioned that all land records and revenue map of Kamaikka Revenue Village were submitted to this court as per the order passed in WPC number 6498/03 and Miss Case number 2613/2009. Full stop. It has been further mentioned that all revenue related works were kept in abeyance and no revenue records were available in the office of the Circle Officer, Guwahati Revenue Circle during the pendency of WPC number 6498/03. It has also been mentioned that the said writ petition has been disposed of and the said revenue records have been returned to the Circle Officer, Guwahati Revenue Circle. Further to that, it has been mentioned that the partition case number 7/2011-12 is still pending in the office of the Circle Officer, Guwahati Revenue Circle, and would be settled as per the relevant rules applicable in case of partition of land in the state of Assam. This court put a specific query upon Mr. N. Gustami, the learned counsel, appearing on behalf of the Deputy Commissioner as to within what time the said partition proceedings could be completed. The learned counsel submitted as per his instructions.
There's no instruction. Period is.
Huh?
Time is not instruction.
No instruction.
No, regarding period of time.
You have no instruction.
No, that.
The learned counsel submitted that he has no, however, he has no instruction as to within what period of time the said partition proceedings can be disposed of. However, he submits that the Deputy Commissioner Kamloops Metro shall take appropriate steps so that the said partition proceedings is culminated at the earliest. Taking into account the above, the instant writ petition therefore stands disposed of, thereby directing the Deputy Commissioner Kamloops Metro to either by himself or through any other officials under him to dispose of the said partition case number 7/2011-12 as expeditiously as possible, preferably within a period of 6 months from the date a certified copy of the instant order is served upon the Deputy Commissioner Kamloops Metro, Mr.
AHMR2.
So and so appearing on behalf of the respondent number 4. Mr. So and so appearing on behalf of the respondent number 4 submit that the Deputy Commissioner should also hear the respondent number 4 before passing any orders in the partition proceeding. Within this code. There is the communication so submitted by Mr. S. Bolwa and Gusami is kept on record and marked with the letter X. All the matters, this instruction is of Mr. S. Bolwa, you appear. Whenever there is an instruction of Mr. N. Gusami, he appears. Yes.
58.
Yes.
My lord, in this matter, on the last of it, my learned friend appearing for the respondents 1 to 6 had submitted that they would file the.
Oh, have you filed affidavit?
They have filed today, my lord.
We file it today.
You
They-
filed?
Yes,
Today,
we
my morning, they have filed today. my lord.
You file reply?
I'll take some time.
Mr. H. Puragwai appearing on behalf of the petitioner seeks for an accommodation for filing the affidavit in reply to the affidavit in opposition filed by the respondents. List the matter of the forwards.
I'm deeply opposed.
Can it be little less, sir? It's a termination matter, my lord, because I am told that because of.
Did it stay?
There's no,
No, there is an observation that subject to outcome of this writ petition, because of pendency, my lord, otherwise everything ready, they have not given the work. They have not issued the NIT for the balance.
my lord, my termination was made subject to outcome of the current case, my lord. So my learned friend is saying that they have not been able to proceed with the remaining part of the work, which was given. to
Otherwise,
me.
everything has been done, balance work, they have assessed, tender is to be.
Be listed again on
Up to the-
16th of August.
16.
The affidavit in reply be filed in the meantime.
deeply opposed.
59 to 61.
In this matter. My lord, last occasion, your lordship was pleased to direct us.
Oh, yes.
This is the instruction I have written.
What is the status of payment of
Yes,
compensation?
payment, my lord, on 21st of June, my lord, July. Circle office has completed the assessment for out of 15 cases, 12 cases, my lord. The collector on 25th placed the demand to the acquiring authority.
That is the instruction I have.
To the requiring authority.
Yes, to the requirement.
Who is the requiring authority?
Water issues.
You are.
Yes, I am for the DC also, my lord, for.
Understood. So the demand
So
has been
at
made
this
to
stage,
you.
my lord, since lordship has directed us to obtain the instruction and to furnish the same, my lord, it will be a small affidavit. I'll file, my lord. Lordship will grant me 7 days time. I'll file.
Okay, you file your affidavit.
That will be better, my lord.
The DC has requested the water resource.
My lord.
Now, water resource is to give the fund. Now, what is the present position of the
That is
acquisition
the
procedure?
present position, my lord. Only on
This
start,
is as regards the funds.
my lord.
But what is the present position of the acquisition? Has your land been taken?
Yes, yes.
The land
That
has been
has
taken.
been constructed because it is 13-kilometer, my lord, embankment, my lord.
Okay.
To protect the lakhs of people, my lord. They can keep to that.
So the land has been already taken.
Yes.
So have they initiated the proceedings under section 9?
Yes, yes, proceeding, my lord,
Yes.
that has been initiated. In fact, my lord,
So award has not yet been passed.
yes, that part is there, my lord. Authority will take that because it's a, my lord, NABARD funding scheme it was. That is why-
Understood, but award has not been passed. But why is the deputy commissioner not passing the award?
Oh, my lord, only, I think, my lord, after placing the demand, my lord.
Why is the
When-
demand required?
My lord, to make available the fund, my lord.
No, fund will come. That's a different thing. But why is the deputy commissioner not passing the award? The deputy commissioner is the
My lord,
is-
I think.
he's not going to. He is the. Is it the thing which I have seen out here?
Right.
That is it that the deputy commissioner goes as per the dictates of the requiring authority? No, that can't be the law.
So for.
The deputy
award-
commissioner has to take into account as per the provisions of the rules or the act.
Yes,
The act categorically says that you are now to take into account as per the Right to Fair Compensation Act. Earlier to that,
yes. Compensation will get as per the new act, no doubt about this.
no, that is okay, but he is going to get, I understand, but why is the deputy commissioner not passing the award? The deputy
Award.
commissioner has to
That-
pass
that
the award.
part, my lord, covering all these things, I'll file it.
I think you filed two affidavits.
As directed by this honorable.
Both of us.
It won't go. Only thing, my lord, as directed by this.
No, it's
honorable court.
okay. You bring it on record, but I think you to file two affidavits, one by the deputy commissioner, one by the Water Resource Department. No,
My lord,
because
in
one is
one
the
affidavit,
requirement.
I think it will cover, my lord.
No,
deputy
it
commissioner.
can't. Because there is a conflict.
No,
The
there is no.
deputy commissioner and the water resource cannot file an affidavit together. Because deputy commissioner is asking for the requirement from the water resource.
My lord.
Water resource is going to make the payment. Then if both of them file it, then what is the difference between the collector and the requiring
That part
authority?
I will clarify, my lord. All right.
The Mr. B. Kuswami, the learned edition and
Only
advocate general.
prayer is, my lord, lordship may kindly mention this because as per your lordship order, instruction has been received.
Advocate General, appearing on behalf of all the respondents, has submitted that the Deputy Commissioner had made the necessary assessment and had submitted the required had submitted the details to the requiring authority, that is the Water Resource Department of the Government of Assam, for the funds
12 LKs against 12 LKs
against 12 land acquisition proceedings.
out of 15.
This is 15.
Total 15.
Now here, we are concerned with
Here, within this 15, petitioner case will come.
within this 12 it will come.
Sorry, within this 12.
So we are concerned with this. Taking into account the above, this court directs both the Deputy Commissioner Kamlukna,
No, my lord, Morrigan.
Moriga, as well as the Water Resource Department to file their individual affidavits, bringing on record their stand. This court further directs the Deputy Commissioner to state on affidavit as to why the affidavit, why the award has not yet been passed. List the matter again on 16th of August 2023. the affidavits be filed by 10th of August.
May I pay for this order?
Hmm?
So that I can communicate.
No, nowadays ask your junior, he can take it out from there.
My only thing, my lord, sometimes
It's available on. Nowadays everything is online.
in that, public.
62.
So we'll come on,
I only give a
Like
copy of the award of the order when I say that the order has to be from today.
my matter will come on 16, my lord.
16th matter is coming up.
Can it be on 17, my lord?
17th is August, Thursday. Thursday I don't do it.
Friday?
Friday is closed. You may only come.
That day holiday, my lord. Then
And
next,
15th is,
yes, yes. Then my lord, next Monday.
Okay, let the matter be listed on Monday. You file your affidavit by 16th,
All right, man. Then will be listed on my lord,
21st.
21st. All right.
Yes. Oh, that day I got hold of that judgment. You got it?
Your lordship,
Of the Supreme Court judgment?
your
That day I got it.
Your lordship, the judgment I have also got it, your lordship.
Hmm? My judgment?
Your
Or judgment?
lordship in WPC
Hey, this one. This judgment. Dilip Dead versus Satish and others. 2022 SCC Online SC 6810. Herein it says, now it is now well settled proposition of law that electricity is a basic amenity of which a person cannot be deprived. Electricity cannot be declined to a tenant on the ground of failure of the refusal of the landlord to issue no objection. All that the electricity supply authority is required to examine is whether the applicant for electricity connection is in occupation of the premises in question. Isn't it?
Yes,
Did you
sir.
get this judgment?
Your lordship, I got the.
No, if you didn't get this judgment, I am not passing an order in your favor.
Your lordship, I got the judgment of 2016 Supreme Court.
I know.
Regarding,
Year
regarding,
2020.
regarding this tenancy matter, your lordship. Regarding tenancy, Supreme Court.
Yes. Restore connection or trade license. Give it. You are,
I'm for response number 5.
that is
That is the
Landlord,
landlord,
your lordship.
one of the land,
5 and 6.
5 and 3. I'm appearing for 5.
Okay, 5 and 6. Okay. But whatever may be, both of you have you have any problem, you go. But the trade license, this is a case of a trade license being not renewed by the GMC on the basis of no objection.
So far,
The instant petition has been filed by the petitioner, being agreed by the action of the respondent authorities, respondent GMC authorities in not renewing the trade license of
No,
the
you're
petitioner,
cancelling my trade license.
in cancelling the trade license of the petitioner on the ground of
No,
the
ground-
landlord. Huh?
no ground has been written. The cancellation order say, as per commissioner order, your trade license is cancelled.
No, the instant petition has been filed challenging the order dated 21/12/2021 issued by the Commissioner GMC, whereby the trade license of the petitioner was cancelled with immediate effect. When the matter was listed on 21/7/2023, Mr. P. Nayak, appearing on behalf of the GMC, had submitted that the trade license was cancelled on account of non-furnishing of the no objection certificate from the landlord. That is the respondent number 5 and 6. Although it is well settled that an order passed by a public authority is required to contain reasons, and reasons can't be supplemented at a later stage. In order to make the order good. But taking into account the issue involved, this court is of the opinion that it is required that the order dated 21/12/2021 be tested on the basis of the reasons so stated by Mr. P. Nayak, the learned counsel appearing on behalf of the GMC. The learned counsel, the petitioner herein carries on the business of what? Carries on the business of a pawn shop in the name and style of Orun Pawn Shop, and had obtained a trade license for the same from the respondent authorities. The same have been renewed. The entire livelihood of the petitioner is based upon the said pawn shop. The said trade license have been renewed by the respondent GMC authorities from time to time. However, on account of the no objection not granted by the respondent number 5 and 6, the GMC authorities have cancelled the trade license. It is under such circumstances the instant writ petition has been filed. This court finds it relevant at this stage to observe that without a trade license, the petitioner cannot carry on his business of his pawn shop legally. Under such circumstances, the livelihood of the petitioner is dependent on the said trade license. It is the opinion of this court that the respondent GMC authorities cannot decline renewal or can even cancel the trade license on the ground of failure oblique refusal of the landlord to issue the no objection certificate. If the under such circumstances, the instant writ petition therefore stands disposed of, thereby setting aside the order dated 21/12/2021 issued by the Commissioner GMC, Pan Bazar, and further directing the Commissioner GMC to renew the trade license of the petitioner? Subject to the petitioner complying with the other terms and conditions of the trade license. With the above, the instant petition stands disposed of.
Much obliged.
63.
Yes, Mr. Das.
In this case, I'll seek one more recommendation to file a reply to
Oh.
the affidavit filed by the respondent.
You are enjoying an interim order?
Yes, Lordship.
We vacate it?
No, Lordship, one more opportunity, but
Till the next date, the order dated so and so password shall not be acted upon. What is that order?
it's a demolition order.
Then, why you asking for so much of time?
No, Lordship, I'm still to receive certain instruction from my client.
What is there? The affidavit was filed
Lordship.
when?
Filed that
It is
affidavit in
long back,
February.
Affidavit in opposition filed on 22/2023.
One more opportunity.
Then why is it taking 5 months for you?
No, Lordship, I have, the day I have received the affidavit, I have communicated to my client. Some clarification I have still to receive. One
Since when? Last time also you were seeking
Yes,
before
yes.
vacation.
Yes,
The entire vacation have gone, you have not taken any steps.
I'm still to receive one more opportunity as a last opportunity.
Mr. Didas appearing on behalf of the petitioner seeks for an accommodation to file the reply. Mr. Esbora appearing on behalf of the Esbora appearing on behalf of the
1 to 4.
GMC, na?
Not the GM.
Huh?
GMC lot. 1, 2, 3, 4, and 5.
GMC submits that the affidavit was filed by the GMC
20.
on 22/2023. However,
That's one number 6 there. We have to find out.
he further submits that the petitioner had also taken time on 23/6/2023. And is delaying the matter after obtaining an interim order. So taking into account the above, list the matter again on 16th of August 2023. Affidavit be filed by 11th of August, 10th of August 2020.
Interim order.
Interim order passed earlier shall continue.
And if you
64.
May I please allow?
Hmm.
May you please to peruse order dated 2/6/23.
Yes, tell me. What is this matter about?
Lordship, the petitioner herein is the
Permitted
company.
to resume the factory on any condition that may be imposed by this court. Yes, are you operating the factory?
The factory is an integrated factory. One portion has not been operational, the other portion is operational. So the raw
Mr.
material,
Council, is this Purbanchal cement is which one?
Surya Cement.
Huh?
Surya Cement, Sonapur.
Yeah, the entire not before me.
No, not.
Won't be proper. I have, yeah, I was the retainer all along earlier.
But if there is some urgency, day after tomorrow, if there is some urgency because the factory is shut and every day we are.
Day after tomorrow.
Day after tomorrow, let it be, because in any case, the response number 5 has nothing to say within the government, which has to respond.
My lord,
Day after tomorrow.
my lord,
Every day we are losing.
Well, I have to say, my lord. He cannot say, my lord.
Not before me. List the matter before any other bench except me. The petitioner, the counsel for the petitioner expresses urgency. The counsel for the petitioner shall approach the registry so that the matter be listed at the registry shall take a call on such request so made.
Deeply up.
Because I don't pass an order when I can't take it. Yeah, for that. In
Item number 37 for order.
Yeah. 37. Okay. List the matter after 3 weeks. In the meantime, the respondent contempt shall file their
38.
Yes,
Respondent have entered appearance.
you have filed affidavit.
My lord, I am appearing for the respondent of 5 and 6. 2 weeks time may be granted, we will file our response.
The counsel appearing on behalf of the respondent number 5 and 6 request for an accommodation of 2 weeks for filing the affidavit in reply, affidavit in opposition. List the matter again on 308/2023. The affidavit be filed by 23rd of August 2020.
My lord, I enter appearance on behalf of respondents 1-4.
You are filing affidavit. You
We will
have
also
to,
file affidavit, my lord. In the meantime, we will also file affidavit.
Mr. A. Burwa. No, itu agote the counsel appearing on behalf of the respondents appearing on year 6 for an accommodation of 3 weeks for filing the affidavits. So list the matter again on 30 of 30 this, no?
23.
Huh?
23.
38/2000. The affidavits be filed by 23rd of August.
Okay.
39.
Yes,
May it please your lordship. Lordship, this contempt petition has been filed for non-compliance of the order dated 12/10/18,
Hmm.
passed in WPC 7421 of 18.
And it been complied.
No, lordship, they have constructed the second floor of the building
Oh,
after passing of this order.
then
Still now they are proposing to construct the third floor.
where is the order?
The order
Order
is at page
construction of the
22.
building of the respondent number 5 shall not be permitted. Who is respondent number 5? Take Noor Alam. Take Noor Mohammed. Blueberry. Got it. Okay, we do one thing. List the matter again on 2nd of August. Okay,
Public.
because the other side is not appeared, so we'll have it on 2nd of August. 2nd.
40.
Yes, madam.
May I please your lordship kindly peruse page number 13 of the contempt petition lordship. Kindly peruse page number 13 lordship.
30?
Yeah. 1-3.
1-3.
1-3 lordship. Last paragraph lordship.
Uh.
The petitioner shall submit a certified copy of this order to the additional chief engineer public works department, Bodoland Territorial Council for his doing the needful. Here no representation has been annexed and he is not a party here.
Who?
Lordship petitioner should submit a copy to the chief
Whom
engineer.
has he made party?
Chief engineer. Here is specifically stated that
They have made it to the Anurag Goyal also.
what chief
And
engineer. lordship.
yeah. Yes, madam, what is this? How are you filing all these things? These people are not there. Have you issued notice to them? Yeah. How is it possible? You have to ask them. Then look here. You have to comply with this. If you don't, I'm going to send put you to comply contempt proceedings against you. Where is it? What is the verification done? Verification is an amount of rupees 9,33,000. This was long time back, na? Okay, what is your stand? Why have you not made those chief engineer and all this as party? Then you issue notice to somebody, you are not asking them. How do I give you? What to do? You have your senior? Or you are the only one? Who is your senior? Huh?
Aadhaar.
Are not.
Aadhaar.
Hard. Better off. I won't dismiss in your presence. Sir. Okay. Something. List the matter again on. Leave it on 9th of August 2023. On which date Mr. Ardhar, the learned counsel for the petitioners shall apprise this court as to how the contempt proceedings could be maintainable against the respondent number 1 and 2.
41.
Yes.
Lordship, here also the same issue is there. Page
Same.
13, page 13.
Same order.
42.
Here my prayer is, Lordship, some time may be given to file my petition, Lordship.
Yes. What is the non-compliance? Since this order, since the interim order is past ex parte, the respondent, they are at liberty. What is the in view of the till return, no payment be made, released to the respondent number 6 and 7 in respect to the present work. Have you released it?
Lordship, it will be.
Then did you get a copy of this?
Lordship, the executive engineer have not received the copy, Lordship. The concerned Lordship, the assistant received the copy. So I am filing my detailed affidavit, Lordship. In this case. I am filing my detailed affidavit, Lordship.
This has been received by somebody.
Lordship.
When? 35. When did you release it? When did you release it? He must have stated something.
Lordship.
When did he release the funds? Mr. Counsel, when was the fund released? Obviously, then otherwise, where is the contempt?
The interim there was a direction of no payment is to be released.
Understood, but when was it released? Was it released before you informed the court authority?
No, Lord, after.
Huh?
After being informed, after they release.
So how do you know? Unless somebody says. The learning counsel, Mr. N. Upadhyay, is granted 3 weeks time for filing the affidavit on behalf of the alleged,
Toll contempt.
on behalf of the alleged contemners, on behalf of the respondent. What? Oh, no, only one.
Sole respondent.
On behalf of the respondent, on behalf of the sole contemner. The said affidavit be 3 weeks time. List the matter again on 23rd of August.
Lordship, let the matter be listed along with the connected writ petition, Lordship.
Not necessary.
No.
First you go to jail, then we will fight.
43.
Yes.
Lordship, we pray for little account because the matter is pending before the Assam State Disaster Management Authority, Lordship. So Lordship may give some time, Lordship. Regarding
No affidavit file.
Lordship, we have not filed, Lordship.
Why?
Lordship will place the complaint. Lordship may give some time. I will file affidavit. Lordship.
What is the order passed?
Order passed in page 15, Lordship. Page 15 of the contempt petition, Lordship.
What is the direct?
In last paragraph, Lordship, in the event
In the event of filing representation to the directed within the time of the deputy commissioner for verification. Yes,
Lordship may give some time, Lordship, because there is no budgetary head is there, Lordship, in particular. As per the OM, Lordship, notification budgetary head should be given, Lordship. It is not, so some time may be required, Lordship.
how much?
Lordship may fix it after 4 weeks. In the meantime, we will, Lordship.
Comply.
Lordship.
Comply. There is no affidavit. This is a comply.
Lordship, Lordship.
List the matter again on. Eleventh of September 2023.
Lordship, Lordship.
Stop. On which date the learned counsel appearing on behalf of, on which date the respondent shall apprise this court as to whether the order has been complied with or not.
Lordship, Lordship. Oblige, Lordship.
No affidavit business, huh?
Lordship, Lordship.
This is a case of compliance.
Lordship.
44.
Yeah. Service complete. Service complete. List the matter for admission after 2 weeks.
55.
क्या इसे पूछा? उनको बोले। Huh? No. Why the matter has come today? Service complete.
Lordship, matter is in fact so matter is pertaining to the settlement of part, Lordship.
Why the matter has come today? So you want the setting aside, striking out of the name of respondent number 11 and 12?
Lordship, but yes, Lord. But now matter is infructuous.
Infructuous.
Yes, Lordship. As to why
Okay,
rest
the
NIT
learned
has
counsel
issued-
appearing on behalf of the petitioner has submitted that the repetition has
Yes.
become infructuous and accordingly has instruction not to press the instant petition. Taking into account the above, the instant petition therefore stands dismissed as it has become infructuous.
46 and 47.
Yes,
The respondent number 6 service is completed.
service is complete. Okay. As the service is complete, list the matter for admission in the second week of August.
Yeah.
Second or third video, huh?
Forty-eight.
कागज को नहीं किया लोगों ने। And put him. Yes, 48. You are only appearing.
I'm putting respondent number 5.
Your name to that. List the matter for service is complete.
Number 7.
Okay. Taking into account that the service is not complete, list the matter after completion of service upon the response number 7. Yes, Mr. Nath, your matter.
I'm repeating for the first time, my lord, I got the instruction, give me some time to file affidavit.
What is the order?
Lordship, page 12. Paragraph last 2-3 lines. Paragraph.
Well, now, response number 7 over 51. Yes,
Page 12, Lordship.
this is 40.
49 is.
49. Page 12.
Okay, right.
After completion of the correct amount entitled to by the Chennai will be reduced in 3 months. 6 years. Yes, what is it? So this exercise be completed within 3 months. And the amount be released entitled to by the Chennai be released.
My lord, actually, when the lordship is passed the order, I think the petitioner who have told your lordship, my lord, this process is not by the commissioner. It takes a big chance because there's a voter list. There is a change of names here and there. Law exercise has to be done, my lord. What is done? The commissioner has been directed by the government to do it through chief executive officer of a particular district. It is being done. He has done it. He has sent back the entire matter to the government along with the entire voter list, and the evaluation has been done, my lord. Now, after that, the governments, what they do, they make a cabinet memorandum, my lord. It is being passed in the cabinet, my lord. That's the procedure. The commissioner has done everything. It's pending with the government now. Now, I find there's one respondent number 1 is implemented. There are other respondents. Had he implemented the other commissioners, principal secretary, my lord, probably he could go to answer today, my lord, because commissioner has done his part now. He has sent the matter to the government, my lord.
He has only made the commissioner.
Yes.
Just
Because of the
Lordship,
direction,
say-
probably. That's why I say,
Okay.
while passing the
Now,
order.
now you bring that aspect on by way of
Yes, my lord. That's what I
Lordship.
Yes.
Mr. M. Nath, the senior counsel, appearing on behalf of the respondent number 16 for an accommodation of filing an affidavit, taking into earlier that the petitioner, the respondent number 1 has already done his part.
Yes, ma'am.
Taking into account the above, let the matter be again listed on 16th of August 2023. The affidavit be filed by 11th of August.
Item 50.
Lordship, may I pray, Lordship? Respondent number, sorry, the finance department, Lordship, their only direction is to take assistance from the finance department for correction of the Lordship, the order reflect. So my respectful submission, Lordship, he is the main person, Lordship, to
Commissioner, let him reply. You have only made only one person. So
if
you,
necessary, Lordship, I'll file an application for
Eileen, you have to issue notice to them. Ask
Yes.
him to issue notice for compliance.
Lordship. In the
Okay.
meantime, Lordship, I will file my also, Lordship. If it does.
Yes, who is appearing for him? Copy of notice issued to the copy of the.
Kindly peruse the office note dated 9/6/2022.
Is the service complete?
Yes.
It is not clear as to whether the service is complete. What is the order pass?
At page 12.
Inquiry of the confusion regarding enforcement here. Who are you? So and so have been with the. We'll do one thing. We'll have it on again, Madam, 14th of August. Huh? Because the other side is required to be represented.
Yes. Actually, they directly send a communication letter to the register of Guwahati High Court.
Now, there is one letter sent by to the circle officer by the additional deputy commissioner, and there is some that is the document.
Yes.
list the matter again on 14th of August 2022. In the meantime, the respondent would be at liberty, the respondent may file the affidavit.
51.
We have filed it iterative application for allowing us to cut out 1 week time, 1 month time for comply of the honorable court order dated 16th.
What order?
This honorable court filed order dated 16th profit while after conditional
16?
interim order 16th profit. Page it start from page 21 of it.
Huh?
The direction is page 24.
Okay.
Page 24.
Of your eye.
Yes.
Two of your eye. Yes. What is that order?
Page 11 of it, paragraph 12. Immediate as the hearing.
Oh, this one. I remember I was in the division bench. You are being asked
Yes,
to pay
yes,
some payment. Why haven't you made the payment?
Doctor pay within 1 month because that order was division that order was
Oil India is in doldrum.
there.
Eh?
There is delegation of power lordship up to 5 crores lordship. Corporate board is the appropriate authority. And after since this order was passed in respect of 9 crores
You were lucky to get this order and then also you are not paying.
so within 1 month.
If I was the person concerned, I would have asked you to pay 44 crores. People have asked you only to pay 22 crores. And this court have further reduced to asking you to pay only 6 crores 30 lakhs.
6 crores, no, 9 crores. Original award was 6 crores.
Then 9 crores only. You have paid 44 crores. Yes. When?
Within 1 month.
Let them pay. In 1 month.
Lordship, only request is if you can fix a date so that we can confirm compliance
Yeah.
after a month.
The other matter, I fix it on that day. I dispose of this and fix this petition on that day.
Obliged, Your Lordship.
The instant application has been filed. Seeking extension of the period for compliance with the direction passed by this court on 16/6/2023, passed in WPC number 3367/2023. It is relevant to take note of that this court had by the order dated 16/6/2023 directed the petitioner to deposit an amount of rupees 9 crore within
1 month.
where within a period of 1 month from 16/6/2023. The learned counsel appearing on behalf of the petitioner submits that on account of certain approvals to be taken, the said payment could not be deposited with the Deputy Commissioner.
Yes.
Deputy Commissioner Tinsukia. However, the same would be deposited within
1 month.
No. Not 1 month. Let us see. When did you file the application?
17th.
On 18th of July.
17th.
By, we fix a date. You, on that day, you thought 1 month. By 28th of August 2023. Without pay. Taking into account the above, the counsel appearing on behalf of the respondent, private respondent,
Right.
number 5, has no objection to the same. Taking into account the above, this court therefore directs the respondent and therefore directs the petitioner. Therefore extends the period stipulated in the order dated 16/6/2023 for payment of the amount of rupees 9 crores in the office of the Deputy Commissioner Tinsukia, thereby within 28/8/2023. It is further made clear that if the said amount is not deposited within the time so granted, the interim order so passed on 16/6/2023 shall automatically stands vacated without any further reference to this court. এখন এইটো হৈ গ'ল। I extend this book. এখন দিব 16/2. List the matter again on. Oh, yeah. Yes, madam, when?
28.
No, not 20. 28, they have to deposit. Otherwise, it gets vacated
Also, whenever convenient.
on
Your lordship.
11th of September.
July, your lordship.
It will read petition, huh? List the matter on 11th of September. In the meantime, the respondents may file their affidavits. What? I said that, huh? If you don't pay by 28, the interim order stand vacated.
Oblige, your lordship.
52. Oh, yes, now you think. That one, 3 and 4.
Yes,
You have taken steps. You'll take steps. It is over. The steps have not been taken.
So 1 week time.
সেইটোৱে আগৰ এটা যে order হয় এটা, huh?
1 week.
1 week time.
53.
53 also same.
Obviously.
$65?
65.
But here I pray for some person to file my affidavit.
What is this matter?
Matter relating to deceleration exercise was taken. And thereafter the order was
What
passed to
exercise?
Deceleration exercise of the drains. Matter. Thereafter order was passed, so it was terminated. There the order was passed to
Payment be made expeditiously. What is this? Okay, Mr. Esbora appearing on behalf of the respondent number. On behalf of the sole respondent, 6 for an accommodation for filing the counter affidavit. List the matter again on 23rd of August 2023. The affidavit be filed by 17th of August.
68.
68 na lagi. None appears on behalf of Peru to the operational basis to be to the notice upon the respondent by way of the PS. Okay. Service being completed, list the matter for admission in the 3rd week of August. Well, so many leads.
But ASFP